Good afternoon. This session of the Appellate Division is now open. My colleagues and I welcome you all. I'm about to call the calendar, and I will reaffirm to you the time that has been allotted for your arguments. You needn't answer this calendar call. If I have any questions about the call, I will ask you. Let's start with People versus Michelle Graham. The appellant has 4 minutes and 1 for rebuttal. The respondent has 4 minutes. Brass Tax Alliance versus Lewis. The appellant has 5 and 2 for rebuttal. The respondent has 5 minutes for argument. Marcia S. versus Troy R. The appellant has 4 minutes for argument. The respondent is submitted. Pickin versus RN Realty. The appellant has 5 and 2 for rebuttal. The cross appellant has 5 and 2 for rebuttal. Herrera versus Kent Avenue Property. The appellant has 5 and 2 for rebuttal. The cross appellant has 5 and 2 for rebuttal. Has respondent Herrera, has Mr. Shaw appeared? I'm going to mark Mr. Shaw as having submitted on behalf of respondent Herrera. Schatz versus Shertock. The appellant has 5 and 2 for rebuttal. The respondent has 5. Barahona versus Marcus. The appellant has 6 and 2. The respondent has 6. People versus Axel Carrera Robles. Is there anybody that has appeared on this proceeding, on this appeal? No person having appeared, we're going to mark it submitted. Plekhanov versus New York City DHPD. The appellant has 5 and 2. The respondent has 5 minutes. Ernji versus Kim J is submitted. Han versus New York City Transit Authority. Appellant Davies has 5 and 2, and the respondent has 5. People versus Annette Spahn. Is there anybody present on this appeal? No one having appeared or answered the call, I'm going to mark it submitted. Menkes versus Solomon and Kramer. The respondent has 4 and 1 for the appeal. The appellant has 4 and 1 for the appeal, and the respondent has 4. Winslow versus New York Presbyterian. The appellant is marked submitted. Each of the respondents has 3 minutes each. 160 East 84th Street versus New York State DHCR. The appellant has 5 and 2, and the respondent has 5 minutes. Willis versus MTA is submitted. Town Center Partners versus Castro is submitted. The first argument for on the calendar, People v. Graham. You can proceed.
Good morning or afternoon, Your Honors. Robin Richardson with the Legal Aid Society on behalf of Ms. Graham. Ms. Graham's sentence of 21 years for manslaughter is excessive, and we're asking this court to reduce it to 15 years. This is Ms. Graham's first violent crime. She has no prior history of violence or use of weapons. And at the time of this incident, she was 34 years old. Now, she had grown up in foster care, she had aged out into homelessness and drug abuse, and in spite of this traumatic life, had not had a violent incident until she was 34 years old. It's very clearly an isolated incident, and she received the near maximum. Now, the legislature contemplated a situation in which somebody with this exact crime could receive 8 years, and yet Ms. Graham received 21.
This is just, yes, this was a plea to a reduced charge, though.
Yes, Your Honor, she was
Right.
charged.
So what was the sentencing exposure on the charged crime?
I believe 15 to life. However, if you look at the facts of this case, it's much more like a manslaughter than like a murder. There was one shot. It was not to the head or to the torso, but to the thigh. And the fact that the court and the prosecutor agreed to and let this plea go forward really speaks to the fact that they believe that this was the correct crime for Ms. Graham to plead to. Otherwise, I don't think they would have accepted it. Now we're requesting 15 years. She's already served 9. She'll be 49 years old at the time of her release. This will be sufficient to punish Ms. Graham, but it'll still give her a chance to do something good with her life when she's released. And I sent the court this yesterday, but I noticed that yesterday this court reduced a sentence in a manslaughter case from 18.
We have it. Thank you. It was distributed. I want to just confirm that to you. We got that. Thank you.
Oh, lovely.
Some of us were on that panel.
Yes.
Right. Yeah.
And you know that was a reduction from 18 to 14 years. In this case, I'm asking for 15. And I'd like to really quickly touch on the waiver. I don't believe this waiver was knowing or voluntary. First and foremost, the oral explanation was cursory at best, and the written waiver was signed before the court even addressed the waiver of appeal. And the court didn't ask Ms. Graham if she had a chance to speak about the waiver with her attorney, if she understood it, or if she had even read the waiver before she signed it. And if nobody has any other questions, I'll turn it over to opposing counsel, Mr. Tarbuck. Thank you.
Any of my colleagues have any questions? All right, let's hear from respondent. Let's hear from the people.
Good afternoon, Your Honors. Michael Tarbutton for the people. Your Honors, the waiver in this case was valid. The defendant signed a detailed and comprehensive waiver for right to appeal. And while the court's oral advice was very terse, it was also very targeted and pragmatic. The court reminded her that she was still retaining her right to raise certain constitutional claims, but told her you're giving up your right to ask the appellate division to review the terms and conditions of your plea and sentence. That's exactly the claim she's raising here. She waived her right to raise excessive claim advisedly, and her waiver should be enforced against her. As the merits, Your Honors, defendant argues that the people in the court found that this disposition was appropriate. They did, not just as to the manslaughter conviction, but as to the 21 years. And that represents the sentencing court's exercise of discretion. The people thought it was appropriate as well. Defendant agreed to it. That is quite a contrast to People versus Letitia Fisher, the case that defendant cites, where the sentencing court actually thought that the sentence in that case was excessive and offered the defendant an opportunity to withdraw her plea. Here, we're relying on the sentencing court's discretion. We're not arguing against that. And this certainly was a very serious crime that warranted 21 years. The defendant had a fight with the victim earlier in the day. She got herself a gun. She came back and found the defendant. She approached the defendant and her friends and says, "I'm going to cap one of y'all," and she shot and killed the victim. Nothing that she did. I mean, it's unfortunate that she's had a difficult upbringing. She's had a difficult life, but that doesn't make up the fact that she killed a 23-year-old woman. 21 years is appropriate sentence to recognize the gravity of taking a life, to provide people in her community with some sense of security, some sense that taking a life is a grave action. Public safety. The defendant, after all, got a gun and used it. That's not something she could easily do again after 15 years. 21 years is certainly an appropriate and necessary sentence in all the judicial sentencing criteria. If there are no questions, then the people rest from the brief.
Do we have any questions? All right, let's hear from Ms. Richardson on rebuttal.
I think the only thing I would add is that, 8 years is also appropriate for this exact plea. So we're asking for 15, and that's it for me. Thank you very much.
Thank you. Thank you both. The next case for argument is Brass Tax Alliance versus Lewis. You may proceed.
Good afternoon. May it please the court. Despite respondent's possession of a 2016 judgment for breach of a contract against a corporate entity, the trial court erred and departed from decades of res judicata precedent by granting respondent a duplicative second judgment against the appellant, the exact same
May I
amount.
ask you a question? Why is this res judicata or even collateral estoppel? Your client was sued in the first action in her individual capacity, and that was dismissed without prejudice, right?
Correct, Your Honor.
Meaning that a new action could be brought against her individually.
Incorrect, Your Honor.
Well, what does without prejudice mean? What did it mean then?
If respondent had not amended the had respondent amended the judgment or amended the pleadings or reserved appellant in her individual capacity, then you would be correct. However, the entry of a judgment bars all claims that were raised and that could have been raised in any subsequent
Against the parties that are party to the proceeding. In other words, had a new action been brought against Point Nuff, then I understand your argument. But your client is a totally different entity, and actually, it's a different theory of liability too. Her individual liability is based on the fact that when she signed as a corporate officer, the corporation did not, in fact, exist.
Sure. However, privity extends to both the party and those that they're in privity with, meaning a corporate officer.
That is true about privity, but why is she in privity? Why? I mean, in other words, and let's say it was an inadvertent that she didn't remember or realize that the corporation she was signing for was out of business, and it wasn't an outright fraud.
As the court found.
Still, isn't she still responsible personally for signing for a defunct corporation? Isn't that the law of the state?
No, Your Honor. She would be liable. She may be jointly liable for the first judgment if the respondent amended his pleading or took post-judgment remedies, such as vacating his own judgment to make amendments to include additional theories of post-judgment liability, such as petitioning for a judicial dissolution or finding that she's jointly liable. But the result of the trial court.
How can she be in privity with a defunct corporation? Because your whole argument is that because she was in privity, she gets the benefit of collateral estoppel. But if the corporation did not exist at the time the agreement was entered into, how can she be in privity with a defunct, dissolved corporation? How can that happen?
Sure. Well, the Court of Appeals has said that privity includes those who are successors to a property interest, those who control an action, although are not formal parties to it, and those whose interests are represented by a party in that action, as well as those who are co-parties to the action. That's Buechel versus Bain, 97 New York 2nd, 295. And in that matter, the court did find privity between a corporate entity and a former partner of the corporate entity in his personal capacity.
But was the corporation in existence in that case at the time the action was commenced?
No, I believe it was unwound, Your Honor, or it was dissolved. Moreover, the result of the failure to apply res judicata has resulted in double damages for the very same contract, the very same cause of action.
Well, why do you say that? Did the plaintiff recover on the judgment against the defunct Point Nuff?
They have garnished.
They have a judgment.
They have a judgment.
They can't recover on both judgments the same amount, but it would be joint and several, wouldn't it? Assuming that Point Nuff, which is defunct, has any assets. I'm assuming it doesn't.
You're 100% correct, Your Honor. It would be joint and several if those allegations were in the operative pleading that we're discussing today. The fact is, the cause of action that she was found liable for was breach of contract, when in fact she wasn't an individual signatory to the contract. It was Point Nuff. Point Nuff was the party that performed it. What should have happened procedurally is post-judgment remedies on the first judgment. The principal outstanding was $68,000.
Yeah, I think we understand your argument, and we'll see if we agree with it. Your time is up, so let's hear from respondent. Okay, thank you.
Good afternoon. My name is Artemis Crusaludis from the Law Office of Michael B. Kramer and Associates. We represent the plaintiff respondent, Brass Tax Associates. One thing that we really need to look at is that this corporation has not existed since 2007. So to say that Pontneuf was a party who performed, or that Phoebe Lewis is the successor or controls a party, or she's the co-party, can't possibly be. This corporation has been defunct for 15 years. Ms. Lewis stated, I would forget to file the annual report. Well, fine, but for 15 years. She also, it was also stated in the brief was that if she paid her franchise taxes, she could revive it, but she didn't. And it's not as if we could say that this was the winding up. This was 15 years of not even total neglect. Trying to hide behind the name when she in fact was in control. And she is liable because when she signed, Pontneuf was no longer in existence, and through all these years she took no steps to revive it or to pay the franchise taxes. So she can't state she's in privity or that this is a de facto corporation. To be in privity, you have to have some sort of connection. You can't, and in this particular case, we could have tried it all before. Back in 2014, which counsel brings up often in his brief, she defaulted and Pontneuf defaulted. Phoebe Lewis was represented by counsel. She only, through her counsel, she only moved to vacate her default. Knowing Pontneuf didn't have any assets, she let Pontneuf default. And she never took any steps to vacate that default. So by acting, she is responsible. She's personally liable because there was no corporation. So it doesn't matter that she signed as president of Pontneuf. She was taking all the action in this case. And we signed this on October 1st, 2007. My client didn't know at the time that Pontneuf had already been dissolved. And at the time that $1 Million Quartet came around, this exclusive intellectual property management agreement was still in effect. And she went behind, she basically cut my client out. My client brought $1 Million Quartet to her. She cut him out, went behind his back, and she precluded Brass Tax from participating. And this was an exclusive intellectual property management agreement. And because Pontneuf did not exist, she is personally liable for signing. And my adversary in his brief does not discuss the fact that she's personally liable. Secondly, as far as these other defenses that he brings up, nowhere in the answer is there any mention of res judicata, not once. The prior action is never mentioned. The prior judgment is never mentioned, and the parties would be jointly and severally liable. As I said before, we could have tried it all in the past. She claimed improper service, and we stipulated with the understanding that we would start again. It was without prejudice.
Thank you. All right, let's hear from rebuttal from your adversary. Mr. Meyer?
You're muted, sir.
Yes. Can you hear me now? I apologize.
Yes, we can.
Yeah, just a threshold note. The third through fifth affirmative defenses clearly articulate estoppel, waiver, and no privity. And I would note that that was a pro se responsive pleading. Again, the most salient fact in this entire matter is that at the inquest, prior to the entry of the 2016 judgment, it was raised to the court, and it was raised by a respondent that the corporation was defunct. And the judge at inquest specifically directed them to amend their pleadings, and with that knowledge, respondent decided to enter judgment.
Or how could they have amended their pleadings at inquest?
The-
I don't get it. By that time, your client had already come in and moved to dismiss for lack of jurisdiction, right?
Yes, at that point, yes.
So amend their pleadings to what? Include her? They hadn't served her. They couldn't go forward against her, not on the
include her.
merit
Sure,
at the inquest.
to either include her or to put a cause of action seeking to pierce Pontneff's corporate veil to hold her.
Well, this has nothing to do with piercing the corporate veil. They didn't exist. Okay. All right. I think we understand your argument. Any questions, colleagues? Okay. Thank you. Thank you
Thank you.
both.
Thank you.
Matter of Marsha S. We only have the appellant on that.
Yes, may it please the court, my name is Howard Pobiner. I represent the appellate Marsha S. This child was born July 5, 2002, and Marsha filed a petition May 14, 2004 in Suffolk County seeking support. This was a joint custody situation in which 2 family court orders were entered in Bronx County, but no court ever knew where Mr.
Counsel, why isn't this action barred by the proceedings in Westchester and the determination made in Westchester denying the petition?
Very good question, because the Westchester proceeding was dismissed without prejudice, enabling Marsha to go back to the Bronx, go before Kemp Reeves, and seek to vacate.
What is your basis for that assertion? Where in the decision does it say it's dismissed without prejudice and that she can come back to the Bronx?
In support Magistrate Fiore's decision, it is without prejudice. That's cited in the brief and it's in the papers.
Where in the record does it say that?
I actually can't tell you because this is a family court case on an original record. I'm appealing from what happened in the Bronx. You're asking me something that happened in Westchester. While I subpoenaed everything to the appellate division, I do not know if that got before you.
So this is Judge Gish. Let me ask a question.
Sure.
All right, so you did bring motions in the Bronx to vacate the 2 Bronx orders. And so we have Judge Roberts, and Judge Roberts in her decision, she didn't, some of the reasons that she gave for denying the application were, 1, her assessment that the 2004 order setting child support and the 2005 suspension were final orders. And she also said that in any event, if the application that you're making, in essence, is to change those orders, to redetermine child support non-pro-tunc, which is something that we don't do. We usually, in fact, by statute, we determine child support prospectively. So leaving aside the issue of with prejudice and without prejudice, and I will say I do share my colleague's concern, because I don't understand a without prejudice marking on that when in Westchester they determine the merits. But let's leave that aside. And why aren't the alternative basis for denial of vacature proper? What's wrong with that? What's wrong with what Judge Roberts did?
There are 2 reasons, Your Honor. The first reason is that Section 413K of the Family Court Act permits the court to go back and retroactively reset support. Second reason is that the Child Support Standards Act, both in family court and in Supreme Court, is mandatory. The court absolutely must make a determination for every year. No court ever made a determination. I was sent back to the Bronx, vacate these orders so it can be done there. We prepared child support guidelines worksheets supported by the tax information for both parties. We were denied a hearing. We were denied retroactivity back to the date of the original filing. And I think that since on September 9th, the support magistrate said, unless you're going to enter an order versus the party that earns the most, we know that the respondent earned the most, but we were never given the opportunity to submit that proof. It was marked as exhibits and it was filed with the court. But then with the motion to dismiss, I never got the opportunity for a hearing. So 413K retroactivity was violated. That's reversible error, and failure to give me a hearing and to find for every year who had to pay how much child support to whom. That's mandatory, and failure to find at least the amount that the statute says is the presumptive amount due from each party. That's mandatory. Every case in every appellate division and the Court of Appeals requires that at least you have the finding of what the presumptive amount is. That was never done here. I was sent back to the Bronx to do it. Then Kemp Reeves retired.
It was sent back. It was already, what, 2018? In
Yes, it was.
2004, which you claim is the original sin because the order didn't have the CSSA calculations. I don't know, and it's a question mark right now, whether that changes the nature of the order from final to non-final. It may only mean that the 2004 order was an error, but having not been challenged, it doesn't make it less final.
Well, I appreciate what Your Honor is saying, and certainly I struggled with that in preparing this, but still, CSSA requires in every year, there's a zero determination, and the presumptive amount of child support due from each party was never determined for any year. No court has seen the information on income from either of these parties. That's fatal reversible error and requires you to send this back. Also, Your Honor, under People Against Agramonte in the Court of Appeals, 87 New York 2nd, 765, the organization of the court or the mode of proceedings prescribed by law and present a question of law even without timely objection. So there is a question of law here. The court must follow CSSA, and even if they didn't do it before now, I respectfully submit that this court is obligated to do it. Cassano and Bast give us the roadmap for what to do, and Agramonte says that you can do it. You can do it here, and you can send it back and have it do it there. Even if the original order was zero, it is modifiable retroactively under Family Court Act 413.
Okay.
So, sir, what exactly happened before the Westchester Family Court?
I only have 4 minutes, and without being facetious, there was custody litigation, there was support litigation, first in Suffolk, then in Bronx, then in Westchester, then back to the Bronx. It took me months to figure out who did what to whom in this case.
Right. Any further questions? Thank you, Mr. Pomina.
Thank you, Your Honor. Pleasure to see you again.
Okay, the next case is Pickin versus RN Realty.
Good afternoon, Your Honors. This is Tim Bauman for Defendant Appellant RN Realty, LLC. Appellant appeals so much of an order denying our motion for summary judgment on a single claim for a purported implied brokerage agreement between appellant and respondents in connection with the sale of a building at 530 West 28th Street and the formation of a complex joint venture in connection therewith. I note for the context of the court for this discussion, a non-party in this matter, which is particularly relevant, is Bauhaus Group, which I'll be referring to repeatedly, which is one of several real estate development companies that were interested in purchasing the property around the time in question, which was late 2012, early 2013. In order for plaintiff respondents Pickin Real Estate to prevail here, what they must prove is that they were first employed by my client RN Realty on an implied brokerage basis, and they brought about the sale of the building. To bring about that sale, the standard is they must have produced a buyer ready, willing, and able to purchase the property on the terms set forth by the seller, or put another way, to bring about a meeting of the minds in connection with the purchase of the building and the formation of a joint venture. There are no triable issues of fact before the court in our estimation, and the material facts are as follows. In or around 2012, my client...
Counsel, we're
Counsel,
not familiar with the record.
I'm sorry?
So the specific question is, the court below found a very specific issue of fact as to whether plaintiff was the procuring cause or a substantial factor in causing it to go forward based on the Bauhaus deal. Why was that determination incorrect?
Yes, thank you for the question. The determination was incorrect for a number of reasons. First of all, we believe the court misapplied the standard. If you review the summary judgment decision, the court was clear that there was no meeting of the minds, and the court found no meeting of the minds specifically because my client, RN Realty, and its principal, Neil Schwartz, were not only interested in the sale of a building, but forming what he referred to as a life project or a joint venture. As you'll see in the summary judgment decision, there are two standards that are set forth by the court, both of which we believe are misapplied, but even with their misapplication, we believe we still prevail, and the lower court decision should be reversed. And I'd like to take the court very briefly through our analysis of the two exceptions as it's...
Well, while you're doing that, I'd like you to discuss the Prime City case and the consolidated property case and why the exception articulated in those cases do not apply, at least to the extent of raising an issue of fact.
Yes, thank you, Your Honor. And I'd like to start with the Prime City, if that would be okay. So the Prime City case is distinguishable here because all of the essential terms of the sale were agreed to by the parties. And that's a very important distinction to make here. And that has not happened in the case at bar. If you look at the record here, and forgive me if I'm going over the record that you're familiar with, there is no evidence that we agreed to any of the terms that were offered in the offer letter set forth at the record at 458. That offer letter was sent to us in December 2012 and contemplated additional negotiations in the form of discussion of a joint venture, reducing any further agreement to writing. That never happened. So if we go back to Prime City here, all of the terms were agreed to, but another important distinction I think that's notable here is that the financial ability of the purchaser was established. And what's notably lacking in our case, and we highlight this in our brief, is a key element to satisfying the sale element of the earning a commission is to prove ready, willing, and able buyer. Now the able portion means financially able. So in order to prove that a buyer is financially able, we cannot, and courts have found that you cannot just rely on testimony of the buyer, but you need something more. You need financial statements, something that establishes the ability of that buyer to complete the sale. And as we note repeatedly in our opening brief, the respondents fail in all respects to offer a single piece of admissible evidence that Bauhaus Group was ready, willing, and most importantly, financially able to complete this sale. I would note also for the court that if you look back in the motion to dismiss decision, Mr. Lopresti, my adversary who will address the court shortly, noted that the respondents intended to introduce evidence that Bauhaus was ready, willing, and able, and they did not do so. So, for those reasons, if we look at Prime City and we compare it to our case, the meeting of the minds on the essential terms of the sale and the financial ability established in Prime City are notably absent in our case. And that's the key distinction here.
Sir, isn't there an important procedural difference between Prime City and our case? Prime City was, I believe, after a non-jury trial. Here we're talking about summary judgment. You sought summary judgment. So did you make a prima facie showing that the buyer that they allegedly procured was not ready, willing, and able to consummate the transaction?
Well, the answer to that is once we, in our estimation, once we made the motion, the burden shifted to have them introduce admissible evidence that, in fact, Bauhaus was a ready, willing, and able purchaser. And because of that burden shift, we believe that it falls on the respondents to prove or to offer evidence to support their claim as a matter of law that Bauhaus was a ready, willing, and able purchaser. And this is an 8-year-old case, Your Honor, and I would offer that within the 8 years, it's telling that not a single piece of evidence, including depositions, affidavits, or financial statements, were procured, offered in the record, and offered in support or in opposition, I should say, Your Honor, of our summary judgment motion.
So,
Yes,
Mr. Baumann, if I may,
Yes.
Wasn't all of this in negotiations over a period of time? Didn't the offer increase, for example, from the initial 30 million, then to 40 million, then to 44 million, and an offer to have a joint venture opportunity for the defendant was similarly offered at some stage. I'm unclear at what point was financial capability supposed to be introduced? Was it during the course of these negotiations? Was it at the time when a price was reached, an agreement was reached as to the prime, or did the defendant simply jump ship after the negotiations seemed to be destined towards conclusion?
Thank you for the question, and I would just start out with your last point, which I wouldn't characterize these as negotiations, and they never approached close to plainly and evidently reaching success, and I'll get to that. Going to your question, over the course of 2012, as you correctly point out, Bauhaus offered a total of 3 offers and increased those offers over a period of time. The final offer, the one that I highlighted to the court earlier, the December 28th offer, was a $44 million offer for the purchase of the property with a passing remark about the joint venture agreement.
And if I may, the
Yes,
ultimate price was $45,000 paid
million.
by $45 million.
It would have been a nice discount. Yes.
Huge. So
Yeah.
so it is possible that the extra million could have been part of the negotiations as well. Could you factor that into what you're saying, please?
We most certainly did, and if I could point the court to our brief, we list a series of offers that we received that went from the low 40 millions all the way up to 56 million from the Blackstone Group. So I want the court to be very clear on this point. Price alone was not our deciding factor in who we were going to go with, and this is specifically because my client's principal, Neil Schwartz, is looking for a life project towards I don't want to say the tail end of his life. I hope he lives a long time, but he wanted a project that he could sink his teeth into, work on, and really have ownership going forward rather than just selling the building, which is the exact reason why the lower court found that there was no meeting of the minds because of this life project and joint venture. But let me talk a little bit about what you characterize as negotiations and just sort of spell out the facts.
And I'm going to ask Mr. Baumann you're way over time
Okay.
Right. So you can answer Judge Gonzalez's question, but then we're going to move on to hear from Mr. Presti.
I apologize for going over, and I'll be very succinct. There was an offer made. It was an unsolicited offer. There was one follow-up meeting in Connecticut with our principal and theirs. Shortly thereafter, after learning of a bankruptcy and that they had no experience in New York, we were entertaining many, many offers at the time. We then met with Centaur, the ultimate purchaser of the property, entered into a standstill agreement, which precluded us from negotiating with anyone else at the time. Judge Oing found that was a absolutely legitimate standstill agreement. We were within our rights to enter that agreement. That ultimately led to the sale of the building to Centaur, not Bauhaus, the entity that forms the basis for this claim, which we believe should be reversed at the trial court level. Thank you.
Thank you. Mr. Lopresti, go ahead.
Yes, Daniel Lopresti, McCalla, Raymer, Liebert, Pierce, for plaintiff cross appellant. Your Honors, very simply, Mr. Pickin and Realty licensed real estate brokers are entitled to a broker's commission because they produced a buyer ready, willing, and able to purchase on terms acceptable to the seller, to RN. And I think the lower court erred in respect to finding
Mr. Lopresti, may I ask you what in indicia of financial stability was offered to the seller? Because your adversary says that Bauhaus was had bankruptcy issues.
Yes, Your Honor. I want to that's an important issue to discuss. Initially, during the negotiations, RN never questioned the financial ability of Bauhaus to do this deal. And never questioned it. Never asked for any proof of financial ability. And I think that's
a reasonable inquiry, particularly on a deal of this size, to want to make sure that the buyer is capable of paying the price that's been negotiated, isn't it, before you have a final deal? Isn't it standard operating procedure?
I think it would be, but I think in this case, there really was no question that Bauhaus was financially able. And in fact, in Mr. Pucko's affidavit that was submitted to the lower court, he went through deals made by Bauhaus at the same time for approximately the same amount of money. And they were able to come up with the capital to make those deals, because after RN reneged on this deal, they went on to other deals, and they were financially able to do that. So we do have in the record the affidavit of Stan Pucko, who was a broker who worked closely. He was a co-broker, and he worked closely with Bauhaus. And he put in his affidavit testimony about their financial ability. But as I said, I think it's telling that RN did not ask for proof during the negotiations. I think they understood that Bauhaus was financially able. So I think we met the burden there. With regard to the bankruptcy, that was an issue never raised during the negotiations. It was raised for the first time during the litigation. And in fact, Mr. Schwartz, the principal of RN, testified that he learned of the bankruptcy at a meeting with Bauhaus up in Connecticut in January of 2012. Well, even after that meeting, there was an additional meeting between RN's counsel and the principals of Bauhaus regarding how the property would be developed, what they would put there, and regarding the joint venture and the like. In fact, that's the meeting where the attorney, Mr. Markfield, says that he exclaimed, "We're going to have a deal." And of course, Mr. Pickett and Mr. Pucko recall it differently, that they were told, "We have a deal." And at that point, depending on who you believe, either Mr. Schwartz or Mr. Markfield even went so far as to negotiate a broker's commission with Picken, which both Picken and Pucko indicate you don't negotiate when there's no written brokerage agreement. The time to negotiate the broker's commission is after there's a meeting of the minds. The contracts may not have been drafted yet, but at that time, that's when you negotiate the commission. You don't do it sooner, before, when there's just negotiations and there's no meeting of the minds. So here we know there was a meeting of the minds because the parties went, even after learning of the alleged bankruptcy, the parties had additional meetings, including meetings to agree on or attempt to agree on the broker's commission.
If I may, what's the time frame between counsel's defendant's attorney saying we're going to have a deal and the time when the opposing buyer was brought into the deal and the agreement was made? Do you have? I didn't do the calculations.
Let's see. It was either the end of January of 2012, or it was either January 29 or February 3rd. I'm sorry, February 3rd, where Robert Markfield stated to Mr. Pucko and Alex Picken, "We have a deal." According to them, like I said, according to Mr. Markfield, he didn't say we have a deal. He said we're going to have a deal, and he related that to a different meeting as well, which may have happened a few days earlier.
And the agreement with Centaur is a year later, February 14th, 2013.
No, I believe the closing on the Centaur deal was in July of 2013. I think it was shortly after. It was shortly after the meeting regarding the amount of the commission.
Right, the sale.
Making excuses.
Yeah,
sorry.
I'm sorry. No, you're right. The agreement was extended 3 times. And then the sale takes place in July, but the initial agreement is in February. So the initial agreement takes place perhaps a year after the attorney's statement, we're going to have a deal, more or less. Is that right?
No, my understanding, it was the same year. I believe the standstill agreement came shortly after the February 3, 2013 meeting, because RN, as I indicated, RN started putting off the brokers and Bauhaus, saying, well, we have to do due diligence, we have tax issues we have to work out. And then a couple of weeks later, it said, oh, by the way, we have a standstill agreement, we're dealing with someone else. And they kind of pulled the rug out from under Bauhaus and the brokers as well. But I was just going to conclude that because Picken brought buyer ready, willing, and able to purchase on terms agreeable and that appeared to have even been agreed on, Picken should have been awarded reverse summary judgment.
Thank you. Let's hear rebuttal.
Thank you, Your Honor, and I'll try to be surgical with my 2 minutes. First of all, with respect to this statement that we have a deal or we may have a deal, the terms of the sale agreement that I discussed earlier, when we're talking about terms to be discussed, the joint venture to be discussed, agreements to be reduced in writing, that had not progressed any further when that meeting occurred with Mr. Markfield in the office, when he said we have a deal or we may have a deal. There were no closer to material terms and a meeting of the minds at that point. That's a critical piece. The other critical piece is whether Markfield, as RN Realty's attorney, may have been excited by looking at this big building that they brought in and said, oh, we're going to have a deal. This is in connection with the sale of a $45 million building in Manhattan and a joint venture where they're building a high-rise building. So their entire case hangs on this thread that there's some triable issue of fact whether what Markfield said binds this agreement. But it's critical that he had no authority. And it's also critical that the material terms had not been discussed and agreed to. There was no meeting of the minds here at all. So regardless of what Mr. Markfield, who I emphasize had no authority to act on his client's behalf, he was just his lawyer. Mr. Schwartz was away for 2 weeks, and he had Mr. Markfield keep the process going of all these people, making bids on his property and fielding these bids. There was absolutely no acceptance of any terms because, first of all, he had no authority, and second of all, there were no terms. So Mr. Lopresti's characterization of some type of ongoing negotiation with a search of the record, it makes very clear there was none. There was no ongoing negotiations. My client was fielding calls from a number of different parties. And Justice Gonzalez, as you point out, the timing of this is important because within 2 weeks, as we're talking to all these people, we enter into a standstill agreement with Centaur because ultimately my client felt that they were the right party to do this deal. And we did the deal with Centaur. We did not do the deal with Bauhaus or any of the other suitors I might offer to the court. There were a lot of people who wanted this building. It was down the street from the High Line. It was as hot as you can be. And my client,
wrap it up. You're over 2 minutes.
And at that, Your Honor, I'm going to wrap it up, and I thank you for your time. We ask that you reverse the lower court's decision.
Thank you. Mr. Lopresti, you likewise have 2 minutes that you're surgically going to abide by.
Yes, and I'll try to keep it even less than that. The only thing I wanted to point out was that the issues of the life venture, the joint development, Mr. Schwartz having an apartment, those were discussed at the meetings and were agreed to. Now, the details weren't worked out, but that's exactly like what happened in Prime City versus Hardy, where there was a meeting of the minds on the essential terms and the details had to be worked out. RN thwarted the natural progression of the deal by failing to continue to work out the details of the joint venture and what apartment he would get, how much
Counsel,
would be.
is there also a question as to who introduced Centaur, the ultimate buyer, to Mr. Schwartz? Whether it was Mr. Pickin or whether Mr. Schwartz was approached independently by someone speaking on Centaur's behalf?
Yes, and I think it should be very clear from the record that it was Mr. Pickin, because he went to 2 meetings with Mr. Berger from Centaur, and one of which Mr. Schwartz was at, and another one where he had a different representative there regarding purchasing the building and entering into a joint venture. Now that's kind of beyond the scope of the appeal, but I think it does go to bad faith, because there was even an offer made by Centaur to RN, where they said, well, if Mr. Pickin is entitled to a commission, we'll pay it. So they were aware that Mr. Pickin was entitled to a commission on that deal. He didn't get a commission on that deal. He didn't get a commission on the Bauhaus deal. He put in years of work, and he did everything a broker is supposed to do to be entitled to a commission. He found not one, but actually 2 buyers ready, willing, and able to purchase on terms agreeable to RN. So for that reason, we ask that reverse summary judgment be granted as to liability in favor of plaintiff.
Thank you. Thank you both.
Thank you, Your Honors.
Thank you, Your Honors.
The next case is Herrera versus Kent Avenue Property. So, the appellant.
Good afternoon, Your Honors. Karen McCarthy of Lawrence, Warden, Reynolds, and Bard for the appellant's respondent, Kent Avenue Property, and J.E. Levine respectfully request reversal of the lower court's order granting plaintiff partial summary judgment under Labor Law 240. Plaintiff's alleged accident is not an elevated gravity-related risk designed to be protected by the types of enumerated safety devices under Labor Law 240 sub 1. Plaintiff's accident resulted from an unrelated workplace accident when he was hit by an excavator and knocked unconscious down to the sloped ground, where he chose to walk directly adjacent to the excavator. The alleged accident and injuries were not proximately caused as a direct consequence of the force of gravity, but from the impact force of the excavator. As cited in our brief, precedent from the Court of Appeals and this court hold that Section 240 does not apply where plaintiff's injury-producing accident was not caused by elevation risk, but related from, I'm sorry.
It's okay.
I'm sorry.
Clear your throat. Take a sip of water if you have.
Okay, I'm very sorry. Was not caused by elevation risks that required the type of 240 enumerated safety devices, but from unrelated hazards at the work site. And those cases in particular, the Nyct case, James v. Alpha Painting, decided by this court, where plaintiff was thrown from a boom truck when the raised boom struck an overhead sign, which caused the truck to swing into the air. And at that point, plaintiff was thrown from the truck into the roadway, causing severe injuries. The court held that the worker's fall was not caused by an elevation-related risk, but by the motion of the truck after the boom struck the overhead road sign.
So Ms. McCarthy, as you understand this case, plaintiff's theory of the case is that he was struck when an excavator rotated, correct?
Correct.
That's the theory of the case. And it just so happened that there was a ramp which he was going up and down because the excavation was into a foundation, correct? All right. You shake your head yes, because I guess you're having trouble speaking.
Yep.
It's all right.
I'm sorry. I did say yes. Can you hear me?
Okay, I can hear you. Yeah, okay. And so is it your claim, just so that I understand your argument, that the issue of the ramp is irrelevant to the accident because the accident was from the motion of the excavator, which was not elevated and not there on account of any, well, it was there on account of an elevation, but it wasn't elevated at the time of the accident. It wasn't part of the elevation process.
Correct.
Okay.
Yes, the excavator was at ground level.
Okay.
And the impetus for this accident was not the direct consequence of the force of gravity. The plaintiff, it's irrelevant that the plaintiff subsequently rolled some 6 feet down the slope after he was struck and fell to the ground. Plaintiff repeatedly testified that the excavator, he was injured when the excavator struck him. It hit the entire right side of his body, knocked him unconscious. And he also testified that nothing else mattered other than the fact that the excavator struck him and he was not going to provide any distances with respect to the configuration of the slope. And courts that have considered whether or not a slide or a roll down a slope is an elevated risk under 240 have rejected that concept. We cited the Timo case from the Second Department, which the court relied on in Anchors. Both of those cases involved slides or rolls down ramps at the work site where plaintiffs were required to be to perform their work. And the courts found that those elevated elevations that were part of the ramp or a slope were not the type of risks contemplated under 240, particularly here when the cause of the accident was undisputably being struck by an accident. And
can I ask you to wrap up your argument because you're over
okay.
time.
All right. I just also want to refer to the fact that plaintiffs have failed to identify any safety device of the type prescribed that would have prevented the accident.
You're over your time. That's in your brief, so we will evaluate that, but I'm going to move on to your adversary at this time, okay? Or you can
thank
raise
you,
the rebuttal. Mr. Roberta, go ahead.
Yes, Your Honors. May it please the court. My name is Christopher Roberta with the firm of Ceruzzi and Spring on behalf of defendant respondent Appellant J&A Concrete Corp. Your Honors, the court awarded summary judgment against J&A as an agent of the owner or the general contractor, finding that J&A was under a duty to provide adequate safety equipment to protect laborers such as plaintiff in their work. I respectfully submit that this finding by the lower court is clearly and explicitly contradicted by the record, specifically J&A subcontract with the general contractor Levine. The specific
didn't the contract itself give responsibility to your client to provide flagmen and barriers?
Just for the portion of their work, Your Honor, just for their work.
But their work was the excavation, was it not? Using the excavator.
They were doing the excavating work, but plaintiff was engaged in a wholly separate task.
But it doesn't matter. He was hit with the excavator while the excavator was turning, or at least that's his claim, right?
And that's why we didn't move to dismiss Section 200, Your Honor, and the common law negligence claims. I agree on that. But with regard to specifically the 240 sub 1, the elevated height, the contract specifically says that J&A Concrete has no duty to provide fall protection for laborers from other trades, such as plaintiff in Newcastle. And that's in the record at 748.
Isn't the claim that this accident happened because he got hit by the exact device that your client controlled, so that the accident arose out of your client's work, and under the law, doesn't that make your client a statutory agent for purposes of 241-6?
No, not at all, Your Honor. That was the whole Wong v. New York Times and the Rice v. City of Cortland, where it specifically says that it's not control over their own equipment, but it's control over the activity plaintiff was doing at the time. That's
Isn't
why.
it control over the injury producing work? Isn't that the question? Whether this incident arose or your client had control over the injury producing work, and wasn't the injury producing work the exact work that your client was in control of?
No, I disagree, Your Honor. I believe the injury-producing work was plaintiff's debris removal tasks that were done wholly and separately at his employer's direction. And regardless of whether he was...
Wait, I have to follow up on that because I'm conceptually having a problem with that. He didn't get hurt because he was removing debris. He got hurt because when he got hit by an excavator, regardless of whether he had debris in his hands or not.
But Your Honor, he was doing the debris removal work at his employer's direction. J&A Concrete had no authority, no duty, no ability to tell plaintiff to go into the excavation.
No, but they had the ability to do this, to put barriers around that excavator and flagmen to say, watch it, watch it. No?
And agreed, Your Honor. And there is multiple testimony from various parties that there were barriers around the excavation, and there were indeed flagmen out there.
But your claim is, as a matter of law, you're not a statutory agent.
Not for labor law 240.
And so that's an issue of fact that may remove liability for you anyway, but not as a statutory agent. But let me ask you another question, because your co-defendant adversary, or not really adversary, because on some levels you're on the same side, argues that this isn't a 241 anyway. Are there any other claims, statutory agent claims under the labor law that would exist if there's no 241 claim?
I respectfully submit that the 241 sub 6 claim would not apply to my client for the same reason that there's no contract provision that requires J&A to provide protection to workers from other trades. There's no contract provision requiring J&A Concrete to be responsible for overall site safety. And there's no contract provision saying that they have the duty or authority to stop work if they observe an unsafe condition. I respectfully submit, in the absence of any contract provision requiring one of those three things.
Counsel, if I may, doesn't Article 12, Section K state that J&A is responsible for providing flagmen, barricades, post danger signs, and other warnings as warranted by hazards and I would emphasize existing conditions? Given this portion, given this part of the contract, this proviso, wouldn't safeguarding human beings, laborers in particular, against the vagaries of a swinging excavator come into play here?
Well, yes, Your Honor. And there is testimony from multiple parties, including plaintiff's co-employee, Mr. Montero, that there were flagmen present around the excavator. There is testimony from a flagman
looking in the opposite direction.
And there were other flagmen as well, according to the testimony of Mr.
That misses the point. That you may not be liable because you didn't violate the statute. But here, all we're figuring out is, are you a statutory agent? Was the safety delegated to you? So the question is yeah, we understand your argument. You say no because he was removing debris. We obviously have some questions, but your time is up. Let's hear from Ms. McCarty. She's got 2 minutes rebuttal, although there's nothing much to rebut here because the plaintiff didn't show up, but go right ahead. It's your 2 minutes. You have to unmute yourself. Unmute yourself, please.
So sorry.
That's all right.
With respect to whether or not J&A is a statutory agent, the court is correct that the injury-producing work was, in fact, conducted by J&A. And the case law is pretty clear on that point. I cite the Sanchez case and numerous other cases that segregate out the type of work that caused the injury, which here was the excavator, from what the plaintiff was actually engaged in that had nothing to do with that work. and the injury-producing work is defined as the work that caused the accident, here being the excavator, which J&A was in total control of, based upon he had full authority under the subcontract, and obviously, since he hit the plaintiff with the excavator, he was obviously controlling that work. With respect to our response to plaintiff's arguments in the brief, we rely on our briefs, and also would like to request that the court disregard plaintiff's request to grant them reverse summary judgment based upon
Search the record, right.
and if you request that you grant summary judgment in our favor. Thank you.
Thank you. All right. 2 minutes rebuttal, Mr. Roberta.
Yes, just very briefly, Your Honors. As the Court of Appeals has held, and whether you're an agent is dependent upon the particular agency created by the contract. And again, I would just emphasize that there's not a single contract provision requiring J&A to be responsible for overall site safety, to have the duty or the authority to stop work if they observe an unsafe condition, or to provide protections, personal protective equipment, or fall protection to persons from other trades such as plaintiff and Newcastle. And if the court has no further questions, I'll rest on my brief.
Any questions, colleagues? No. Thank you. Thank you both.
Thank you, Your Honors.
The next case is Schatz versus Chertok.
May it please the court, Douglas Chertok for defendant appellants. I prepared a brief opening statement. A motion to renew based on law under CPLR 2221E requires a change in law. The motion's purpose is to ensure stare decisis, that is, to ensure decisions are based on correct precedents.
I'm going to interrupt you because the Valhalla court is the basis for your change in law, right? The decision in Valhalla. Valhalla specifically cited the Schatz decision, this decision in this case with a CF citation. So how could it possibly, under any stretch of the imagination, be a change in the law where the Valhalla court explicitly acknowledged the Schatz decision with the CF, meaning compare, this is not analogous. We've already considered it in Valhalla, so how can you possibly arguing that that is a basis for renewal or a change in the law?
Yes, Your Honor.
Be sanctioned.
Yes, Your Honor. So I'll give you a hypothetical to make the point. If in this particular appeal, the justices decided to rely on a case called Bob, this court would not re-adjudicate Bob. It would just take Bob's holdings and findings as is. Bob's holdings might be incorrect. Bob's holdings may not have previously considered law, but because Bob is on the docket as law, you would take it as such. I'm submitting to you in this motion to renew.
Say CF then, counsel.
I'm sorry?
Why would we then say CF, which means compare? This case is different, which means we expressly considered it and found to be a different case.
Sure, because again, you'd be accepting that hypothetical case of Bob, you'd be accepting their holdings and findings as being correct. Even if in fact Bob's holdings and findings were incorrect, you wouldn't have, this court respectfully wouldn't have jurisdiction to re-adjudicate Bob. You would take the case as being good law, as you would with any case that's been decided. But as we all know, not every case is properly decided. And I'm submitting to you that this case was not, if I may.
Yeah, but that's even if say it was made, a mistake quote was made, which I take issue with because you already had a re-argument motion and you said you incorrectly decided this. We looked at it again and we said, no, we decided it correctly. And actually with the benefit of the case that you say changed the law, we said, no, there's no change here. This is all consistent and you are wrong a second time. You can't come back for a third bite of the apple saying there's been a change in the law when in fact there has been no change in the law. And in fact, you were adjudicated on an exception to the general rule that went back to a decision cited by the trial court, the Richbell decision, and that was how your case was adjudicated, and you just lost. You lost. You may think that's wrong. We think it's right.
But Your Honor, I'd offer two responses to that. One, there's a First Department case called Johnston versus National Railroad. It's cited in the briefs. And in Johnston, it specifically says, and this is the First Department quoting, there is no bar to granting a motion to renew because a motion to renew may be based on law not previously considered. And what I'm submitting—
But we considered it. It was clearly considered. It was a CF site. It was considered. It's just that I have to say, this is a mind-boggling appeal, sir. For me personally.
Your Honor, where I'm trying to, and I respectfully submit to you, Your Honor, the case of Richbell is specifically based on in the beginning of the decision, the first 6 pages address whether or not a fiduciary duty existed separate and apart from an agreement. Here, in this case, there was no allegation of a fiduciary duty separate.
But then again, all we're getting to is that you think that the lower court was wrong and we were wrong. And I respect that you don't agree with us. I can live with that. But that doesn't mean that there's been a change in the law. And you have to have a legal basis other than the fact that you're just dissatisfied with what we did as a basis for coming back here a third time. That's the key here. And none of what you argue, whether you agree with Richbell, don't agree with Richbell, whether you think we rightly decided your case, didn't rightly decide your case, comes within the change of law. That's not even a question. That's a statement. I'm going to hear from your adversary now.
May I finish the few minutes of my argument time?
It's actually over. The ringer just went over. Okay. And I think what colleagues does anybody have further questions for Mr. Chertoff? No. Okay. We understand your argument. Let's hear from the other side.
Your Honor, thank you, Your Honors. I'll be brief. Daniel Weinberger for plaintiff, respondent Daniel Schatz. I'd first like to note that the parties actually had a 2-day bench trial last week in this case on February 14th and February 15th. So aside from being substantively and procedurally frivolous, this appeal is practically speaking, if not legally, moot.
Well, you don't have a decision on the bench trial, do you?
No.
Okay.
No, we do not.
All
so
right.
That's why I recognize that it's
Thank
not
you for bringing
legally.
it to our attention.
Yeah.
Go ahead.
So there's a reason why Mr. Chertoff is here today arguing this appeal himself. He's a very wealthy man. He claims to be a billionaire.
You know
He
what?
has white and
Can I tell you something? This is largely irrelevant too. You want to argue the law in front of us. You shouldn't be wasting our time either. Go ahead. Argue the law. I don't care if he's rich or poor, happy, sad. Let's go.
Okay. Your Honor. Okay, then I'll just submit that.
Forgive me, but I think it's important. Don't waste our time. Go ahead.
Understood. Your Honor. We would just submit that we believe that the lower court was correct, and we believe that this appeal is frivolous, and we made a motion for costs and sanctions in connection with this appeal. We would request if the court would consider it, that Mr. Chertoff has a history of filing frivolous appeals, that we would also request if the court would consider it, that he not be permitted to file interlocutory appeals in this case until final judgment, in order to avoid wasting this court's time. And
you think that that's within the purview of the appeal, that we stop him from coming to court in the future? Really?
Well, he could certainly present a final appeal, a final judgment, of course. If the court would be inclined. I understand.
Thank you.
No, I mean, just understood. I understood, Your Honor. We've spent a lot of time and money on appeals. That's all. I apologize for the question. We'll rest.
Okay.
No.
All right, Mr. Chertoff, you have 2 minutes.
I appreciate it, Your Honor. And Your Honor, I respect the court and all of its justices and the review of this case, which you've made very clear. I'd like to offer two comments in response, both legally based. One is the case that I cited previously called Johnston versus National Railroad talks specifically that a change in the law includes, quote, law not previously considered. This court, neither the courts in Schatz, obviously not this panel, but the First Department as well as the motion court, never considered the Court of Appeals decision in Clark Fitzpatrick, nor the cases in Dean, nor the case in Sullivan, which all talk about, and in Panettone, which all say that a breach of fiduciary duty requires a duty separate and apart from a contract. Because the complaint only alleged the LLC agreement is why no court found that there was a duty separate and apart from a contract. That issue was never adjudicated, never considered, and therefore it is a, quote, change in law under the definition of CPLR 2221E under Johnston. I have no desire to waste my time, nor desire to waste this court's time. You perhaps may find it irrelevant. I'm a pancreatic cancer survivor.
I do find it irrelevant, sir. None of us are talking about our medical history here on the bench. I'm sorry for you. I'm glad you're a survivor. I wish you only good health.
And so continuing on my legal thread, Your Honor, that if a motion to renew can be based upon law not previously considered, if this court hands down a decision that says there was a breach of fiduciary duty alleged, it will be contravening the Court of Appeals decision in Clark Fitzgerald, as well as in Dean, as well as in Sullivan, as well as in Panettone, that no court has ever previously considered in this case. And that's the reason for the allegation. I hope that resonates with the court.
Thank you. Thank you both.
Thank you, Your Honor.
Barahona?
Good afternoon.
Go ahead.
Samantha Quinn for the Appellant Long Island Ambulatory Surgery Center. It is appellant's position that the decision of the court below should be reversed. The court below failed to consider relevant evidence in its assessment of our moving for summary judgment, and it failed to consider the deficiencies in the plaintiff's opposing proof. Here, there's absolutely no basis for a finding of liability against Long Island Ambulatory Surgery Center. There is no independent act by the surgery center which can be attributable to the surgery center. There's no testimony whatsoever that any facility member—
Isn't the question whether there was an omission that renders your client liable?
Well, there have been—
I mean, here you have a 34-year-old man who dies, has a surgery at an ambulatory center to wait your client, and when things go wrong during the surgery, he's put in a cab or by himself to go from Brentwood, Long Island in rush hour traffic to the city where general anesthesia can be administered to him. There's not even a plan of any kind in place to have emergency transport or general anesthesia on site. Why would your client be entitled to summary judgment? Isn't that a question of fact for a jury to determine whether or not those facilities or that type of transport should be available?
I would argue that it is not, Your Honor, based upon the evidence in the case. There was extensive testimony from Dr. Marcus, the surgeon, Dr. Passia, the anesthesiologist, Michelle Adams, the surgical PA, all of whom attested to the fact that this type of procedure is typically done in this type of facility.
There's also testimony that they were making.
Assuming a client made a prima facie, which I'll assume for purposes of my question, why didn't plaintiff's expert raise an issue of fact by clearly stating that it was inappropriate not to have the ability to convert to general anesthesia or an immediate plan available to immediately transfer to a nearby facility general anesthesia was needed.
Okay, I'd like to respond to those 2 points separately because they're 2 different points. The opinion that we should have been able to convert to general anesthesia is completely unsupported by the record. In 19 years, the surgical PA said she was never aware of a case where transfer to another facility was required. Record at 2183. Dr. Passia, the anesthesiologist, also 20 years experience, never seen a conversion to general anesthesia. And in fact, his testimony was that he had performed 40 to 50,000 eyes and has only rendered general anesthesia twice. He has never performed this procedure, a scleral buckle, in 20 years under general anesthesia.
Counsel, how is that relevant when we know that an emergency by definition is something that may be unexpected or untoward? Why does that make a difference? If you say, well, none of their patients ever had a heart attack, so therefore they didn't have a defibrillator, how does that make sense?
Well, Your Honor, Dr. Marcus testified that he did not consider this to be a 911 emergency when it occurred. He was a surgeon. And what happened was 90 minutes into the procedure, the patient started becoming uncomfortable. They tried to give him some more anesthetic. He was still uncomfortable. They decided to stop the procedure. They stabilized the patient. And once he was stabilized, and during this time, they're trying to figure out how to get him to a different facility to perform the procedure.
Isn't that the problem? They're trying to figure out what to do with the patient. They're trying to figure out what to do with the patient because there is no emergency plan. There is no ambulance available. I assume that there were hospitals in the area. I can think of a whole bunch of them that could have been available. That of course, is not dispositive. But here you have a patient who's halfway through an eyeball procedure, in my layman's terms, and he gets sent with a hole in his eye, tube coming out, clamps coming out of his eye, and he's put in a cab by himself. There is no backup. What has never happened before?
Your Honor, they could have called 911 had it been deemed an emergency by the medical personnel handling this. That's the plan. The plan is if there's an emergency, we call 911. The medical personnel handling this.
So you're acknowledging that 911 was never called to provide ambulance service?
Absolutely. That's Dr. Marcus's testimony. He did not consider that this was a 911 emergency. The patient was stabilized. And I'll give you it's record at 882 to 883. He did not consider this was a 911 emergency. The patient was stable. And in fact, the patient was delivered to the facility in Manhattan. He underwent an entire new clearance, including labs. Echocardiogram was cleared for surgery. There was a 4-hour delay. And minutes into the second procedure, he coded, which begs the question of whether or not, had general anesthesia been initiated somewhere else sooner, would the same thing have happened? He had a congenital heart problem.
Counsel, I'm sorry to interrupt you, but you marshaled the defendant's evidence that would support a finding and certainly a prima facie showing that there were no departures and or no causation. Circling back to Justice Gonzalez's earlier question, what, in your view, are the specific deficiency or deficiencies in plaintiff's expert's affidavit?
The deficiencies are that it's based entirely on hindsight reasoning, that it is speculative, that it fails to address the contentions of the defense, namely, what exactly should the plan have been? And this was not a foreseeable event. It was completely unexpected. He does not give a single indicia of what we should have done differently as for a plan. And how can there be proximate cause when it's rank speculation to conclude what would have been done differently to prevent this unforeseeable, unpredictable, unfortunate event? I believe my time is up. We'll wait for my rebuttal.
Thank you. Go ahead.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent in this matter. I did want to bring to your attention one thing. Ms. Quinn is a terrific lawyer, and she mentioned something with, I think she used the term, I wrote it down, hindsight reasoning. I don't think you can make that claim in this court anymore. You decided a case in 2022, actually in January, called Pedraza. It's Pedraza against TA. I'm sorry, I only have a Lexus site. It's 2022 New York Active Lexus 241. It's First Department 2022. It's a full opinion by Judge Mazzarelli. It does not deal with medical malpractice, but it does deal with a subway accident, and it discusses hindsight reasoning expressly. And I don't think that argument is tenable anymore. I guess my argument is very, very simple. You can have a right to do something, which is essentially what the defendants are saying. They have a right to have a surgical facility that doesn't have general anesthesia, but it might not necessarily be okay to book that procedure. And I think two justices of the court hit exactly on what the plaintiff's expert said. The term he used was convert to general anesthesia if necessary. That's on 1692 of the record. And what he said was that the defendants were negligent for, quote, failing to have a plan in place to allow for the immediate transfer of this patient to an appropriate facility in the event it is necessary. That's 1693 of the record. That's exactly what happened. There was no plan here. I think Justice Gonzalez and Justice Kern and Justice Higgett, to a lesser extent, spoke about what happened. When this patient had a problem, there was no plan. They didn't know what to do. They were going out and they were calling hospitals. They couldn't get anybody. Who are you going to get on a Friday in the summer at 4 o'clock? No one. They didn't even have an ambulance service or transportation service in that particular situation. They put this man in a car service, for God's sakes. Now, I don't care if they never had this before. If I go in for an arthroscopic procedure on my knee, I'm going to have it done in an ambulatory setting. You can have an orthopedist who never had any problems at all. But if I code, if I have a clot, if I have a poor reaction to the anesthesia, you better believe as a patient that I want to know that if the facility doesn't have the instrumentation to deal with that issue, at least they have a plan to get me to a place where I don't die. And I don't think it's unforeseeable, because our experts said that if you look at the way this procedure is conducted, and this, by the way, is undisputed, he's draped in a cape. He's completely covered. There's a hole in his eye, and he's got conscious sedation therapy. Now, we all know that if you go in for an MRI, you could be the coolest person in the world. You have a panic button because he feels like he's entombed. And all I would ask you to do is read the operative report. He was absolutely terrified. He had a panic attack. And the fact that he ended up having a heart attack and died later, that's covered in my expert's affidavit too, where he says, and this is on 1694, that the failure to have a plan in place led to plaintiff, quote, being subjected to multiple hours of stress to his body, including his heart, which resulted from having undergone the stress of a 2-hour awake eye procedure, interrupted when he became agitated, being shipped to a hospital in a taxi cab rather than in an ambulance for over 3 hours in rush hour traffic for continuation of a surgery with sutures, a tube, and a clamp hanging out of his eye with bleeding, and further hours of waiting for the completion of the procedure. I'm not saying it's a 240 sub 1 labor law case, but I don't think I lose as a matter of law on summary judgment. And one final point, and I'll stop talking. The defendant didn't even bother to submit an expert affidavit. They relied on a report that they filed with the Department of Health. I don't think it's admissible, but it's a self-serving report that's not under oath. So everything that my expert said under summary judgment principles is undisputed, because they didn't even bother to get an expert in a malpractice case where you generally need one, both to establish a prima facie case and to establish prima facie entitlement to judgment as a matter of law. If you have nothing else for me, I'll rest on my brief. I'll let you question Ms. Quinn again. Thanks for listening to me.
Thank you.
Just a few things.
Go ahead. Yeah.
In response, there was a plan in place. The plan was, if there's an emergency, such as Mr. Isaac mentioned, a code, a clot, a poor reaction to anesthesia, 911 would be called. Dr. Marcus, the person calling the shots here, decided this was not a 911 emergency. The plaintiff is conflating the roles of the physician and the facility. They have not identified a single act by any employee of this facility that we shouldn't have booked this procedure. We didn't have any determination of whether this procedure was booked. And as for this plan, yes, if there was an emergency, you call 911. That's the plan. Should we have had an ambulance sitting, waiting at every ambulatory procedure that's done in case there's a problem? No. If there's an emergency, you call 911. The doctor, the surgeon, determined this was not an emergency. This is not the facility that should be accountable here. The facility did not act. Nothing further. I will rest on my brief.
Thank you. Thank you both. Plekhanov versus New York City DHPD.
May I proceed?
You may.
Good afternoon, Your Honors. Marguerite Plekhanov on behalf of the petitioner appellant. Your Honors, there are just a few brief points I'd like to make with my time. The primary umbrella point is that the decision below effectively abrogates the HPD marketing handbook and its subordination to the HUD Section 8 handbook as far as income calculation and procedures between marketing agents, the agency, and the applicant to the affordable housing authority.
Can I take from your question that you're acknowledging that if the handbook was followed, then you have no argument here? Your claim is that it wasn't followed.
My claim is that HPD did not follow the handbook.
Had it followed it, then the determination is fine.
Had HPD followed the handbook, the determination that was reached would not have been reached. It would have been reached in the petitioner's favor because it would have the agency would have reviewed the entirety of petitioner's income documentation, which the agency failed to do, which is ministerially required per the Section 8 handbook, which the HPD marketing handbook must follow as far as income evaluation for applicants. Does that answer your question?
I think it skirts around my question, but I know what the answer should be, so it's
okay.
It's
Can
okay.
I?
No, you finish your argument. Go ahead.
So my argument is that HPD didn't follow its own procedures, that there was no ministerially required screening of the 2018 1099 income statements by HPD or its marketing agents. Further points are that there are two key distinctions between this matter and Ozdoba, that they don't intersect. Ozdoba can't be applied over this matter. And that the only reason for rejection of the petitioner's application given in the administrative record by HPD is an income-based determination. None of the other sort of allegations brought up by HPD in the papers below. So regarding Ozdoba, the two key distinctions that I want to refer to, Ozdoba, this court found in 2010 that that the agency in that matter, which was the State Housing Finance Agency, wasn't the responsible for issuing the income determination because the agency in that matter did not issue an independent income review. It doesn't make back then an independent income review or finding of the applicant's income. So there is no determination issued by the Housing Finance Agency in Ozdoba, whereas in this matter, HPD does issue an independent, what it alleges to be a fact-based, what it alleges to be complete review, which I dispute as an incomplete review, ministerially incomplete review of income. So again, in Ozdoba, there is no independent income review by the agency. It merely checks in on what the marketing agent does and says, okay, this is fine, but it skirts around issuing its own determination. Whereas in this matter, the HPD does issue its own Article 78 appealable income determination of the petitioner's income. And the second distinction that is actually in petitioner's favor regarding Ozdoba and regarding Norman, which Ozdoba cites, is that both courts, both times the appellate division found in Ozdoba and in Norman that it was procedurally required and correct for the reviewing party to perform the Section 8 style income review of the applicant's income documentation, which means reviewing not just the W-2.
Counsel, Ms. Plekoa, I have to stop you because I want to go back to the marketing handbook. It says that the previous year's tax returns were supposed to be evaluated, 4 to 6 of the most recent consecutive pay stubs, allowing for increases or decreases. And then when comparing income that might be disparate, that the highest amount is used between the historical and projected self-employment. You have a problem with what part of that?
So that's what the HPD marketing handbook says, and that's only one small part of what the HPD marketing handbook says. That's basically the minimum cursory review. The rest within the city's marketing handbook is that if there is an apparent trend, which would be upwards or downwards of an applicant's income between the time of their application and the time when they're summoned
And
for the
here,
first.
the agency found no pattern or trend to support the lower amount, right?
So that's what the agency says, but they didn't conduct the ministerially required review of the 1099 2018 income pay statements in order to make that determination either ministerially properly or rationally.
Okay, anything further? Because your time just elapsed.
Okay.
All right, let's hear from the other side then. Thank you.
Good afternoon, Kate Fletcher for Respondent HPD. In this case, the administering agent, not HPD, was responsible for tenant eligibility determinations and tenant selections. And accordingly, this court should affirm the decision below. In addition, if this court reaches the merits, it should also affirm because HPD acted rationally in determining that there wasn't any basis to interfere with the marketing agent's determination. With respect to
HPD came up with different numbers though, correct, in its review?
HPD did come up with different numbers.
But however, both sets of numbers, whether it was the marketing agent or HPD, found that she wasn't income eligible.
This is correct, Your Honor, which is why HPD went through the marketing handbook. And Ms. Plekhanov has a complaint, which is that her 1099s weren't reviewed. But you can add additional documentation beyond what you submitted at the interview, only if your circumstances have changed after your application was submitted. But in this case, she's been very clear that her loss of these 2 clients that she says has affected her income happened 5 or 6 months before her application was submitted. So that was in August and September of 2017. And then her application was submitted in 2018. And so it makes sense that that loss of income would have been reflected at that point. And in her own application, which was based on entirely her own calculation, she was still not income eligible. So in fact, the only reason that her application was considered was because of the error regarding the Section 8 voucher. But having considered it, they did so in compliance with the HPD handbook. You're required to submit specific documentation when your self-employment income has a 2-year history. And in that case, for historical income, you rely on the tax returns. And to project income, Ms. Plekhanov was supposed to submit a notarized self-statement estimating her income, or an accountant's or tax preparer's statement. And she didn't provide this at the interview. She explained why she didn't provide the tax preparer's statement, but the reality is she could have provided a notarized self-statement. And because
Let me ask you a different question, Ms. Fletcher. Am I correct in understanding that there was a representation by Ms. Plekhanov that she had a Section 8 voucher when in fact she didn't? I know that the building was Section 8 eligible where she lived, but
right.
If my question gets a yes, if it gets answered affirmatively, then my question is, what's the import of having a Section 8 voucher or not having a Section 8 voucher?
Yes, there was a mistake on the application, which comes from an understanding of what a Section 8 voucher is. And so she was in a Section 8 building, but she didn't have a Section 8 voucher. And the reason that matters is because if someone has a Section 8 voucher, the minimum amount for a middle income unit is waived. So that means that even though she was over income for a low income unit, according to her application, they didn't consider the fact that at $46,600, she was under the minimum for middle income, which meant that on the face of her application, she qualified for at least a middle income because of the Section 8 voucher. So they invited her in for an eligibility interview, explained what she needed to provide, and she didn't provide it. And there are circumstances when you can supplement the information that you provide at the interview, but her situation isn't one of them because her circumstances that she's saying changed happened before her application was even filed and even put into the lottery. And so there was no obligation to look at this additional information, which did not comply with the standards. And having an HPD simply, or the marketing agent, they can't make an exception in an individual case because someone neglected to bring in a notarized self-statement. Because the whole point of the handbook is to evaluate people on equal footing. And an exception here would undermine the quality that they use when evaluating other candidates. If there are no further questions, the city rests on its briefs. HPD, excuse me.
Any questions, colleagues? Thank you. Okay, rebuttal.
Thank you. Quickly on rebuttal. A change in income prior to submitting your application is irrelevant. An applicant has a responsibility at the time of submitting an application to submit the most accurate income for that moment. In this particular instance, the February 2018 application submission, petitioner was in the midst of a slide in her income. So she submitted as best as she could the reflection of her current income. The HPD marketing handbook prohibits denial of an application prior to it being entered into the lottery, which opposing counsel now argues is grounds for dismissal of an application. That's not possible. That's contrary to the handbook. And notably about the confusion regarding the Section 8 voucher, this is a confusion of acronyms. Was there a question? Sorry, I'm having feedback. This is a confusion of acronyms.
Somebody may have a phone on. Anybody on?
I think it's better. Is it better now?
It is.
It's better now. So the confusion regarding the Section 8 voucher or the project-based Section 8 building that petitioner resides in and continues to reside in a project-based Section 8 voucher is the confusion about the obligation to disclose the benefit that she receives, and she does currently reside in a project-based Section 8 unit. So it's a confusion of acronyms.
I'm sorry, Ms. Manslaughter, are you speaking about yourself when you say she?
Yes.
Thanks.
Yes. So me, the applicant, resides in a project-based Section 8 unit and did at the time of application as well. This is irrelevant. There is no procedure for hand-picking an applicant from the lottery, which is random. Petitioner was given notice. It's in the record that she was randomly selected for the lottery. That's the only way to be selected from the lottery, except for a few key exceptions, which would involve different agencies and it would be blatantly clear. There is no hand-picking a person who erroneously marks the checkbox on the application to say that they have a traveling voucher instead of a project-based voucher. And I would say that this is Housing Connect, the first iteration of Housing Connect, the Affordable Housing Lottery application website. The Housing Connect 2.0 that was launched subsequently to this appeal has corrected that issue and has erased that entire box and just makes it a yes or no question. Do you have, in plain terms, plain no acronyms, a voucher that you will bring with you if you move into this building? Yes or no. So it takes away the opportunity for people to make that error because the error is irrelevant. It's a yes or no question the marketing agent asks you. And I objected to this below on record.
And you understand that if you didn't have the voucher, you wouldn't even have been included in this process, right?
That's not correct. It's irrelevant. It's absolutely irrelevant. That's what I argue below in the April 2019 hearing. That's what I argue in my appellate brief, in my reply papers below. in my reply
Yeah,
papers.
let me just stop for a minute because we're spending a lot of time on the Section 8 voucher, whether there was a mistake or not a mistake. Ultimately, the reason that you were denied the right to go forward is they said you were over income in the way that it was evaluated. And you say they evaluated it incorrectly. They say it was correct. And it was neither, and quite frankly, the standard is arbitrary and capricious no matter what. Was it, did it have a rational basis? So that is really the limited issue that we have in front of us. We understand now the confusion about the Section 8. You couldn't bring it with you, so in certain ways, it was irrelevant for figuring out your income, correct?
Precisely, the only
okay. And it didn't go into how they found you over income. They found you over income for another reason, which is either correct or it's not correct, right?
It's either I was found over income correctly or incorrectly, exactly.
Correct.
So either arbitrarily and capriciously.
I think you understand the arguments, and I don't want to get too far afield here. We understand what it is that we need to look at. Were they arbitrary and capricious and how they calculated your income for the purposes of figuring out your eligibility?
May I just add one quick point? Is that
and then you're done.
In Ozdoba and Norman, the two things that are in favor in Ozdoba and Norman is that this court, First Department, upholds that all income documentation, which includes current year 2018 1099 pay statements, must be reviewed according to the Section 8 policies, which HPD is subordinate to the.
And you said that in your argument in chief, right? Okay.
Yes. Thank you.
We understand your arguments, and we'll look at everything accordingly.
Thank you, Your Honor.
Thank you both.
Thank you, Your Honors.
Okay. All right, the next case is Hahn versus NYCTA.
Good afternoon, Your Honors. Daniel Sugarman for Kramer Levin, Naftalis, and Frankel, pro bono attorneys for appellant Mr. Naeem Davis. May it please the court, contrary to the trial court's decision, Mr. Davis's counterclaim against the Transit Authority adequately alleges proximate cause. Based on Mr. Davis's allegations,
Can we reach the issue of the statute of limitations? Why are we jumping right into proximate cause?
Your Honor, we think the easiest thing for this court to do is to reverse and reverse.
Don't need things easy. Tell me what we should do. Go ahead.
So I think what this court should do is reverse and reinstate Mr. Davis's counterclaim on the basis that the trial court erroneously found that Mr. Davis failed to allege proximate cause. I don't think this court needs to reach
the whole counterclaim, both the pre and push. The pre-push and post-push activity.
Exactly. We think the counterclaim should be reinstated in all respects.
And then the issue of the statute of limitations is still in the case, isn't it?
We don't think so, Your Honor. We think this was an untimely motion to dismiss under A5 under statute of limitations.
It wasn't a waiver because it was put into the response of pleading to the counterclaim timely, right?
That's absolutely right. But just because it wasn't waived doesn't mean that it was made in a properly procedure motion. We're not disputing, for example.
But what's the impact of that? Isn't only the impact of that instead of making a 3211 motion, they should have made a 3212 and that the issue should have been reached?
We think it could have been reached on a different type of motion, for example, timely motion for summary judgment. But even if you were to look at the merits of the statute of limitations issue, Your Honor, we don't think it's a winner for the Transit Authority. Mr. Davis's counterclaim must be viewed as, among other things, a claim for equitable recoupment. Under CPLR 203D, a claim for equitable recoupment is never barred, even if it would have been barred under statute of limitations grounds if it was brought as an independent claim. This is a claim for equitable recoupment because it arises out of the same transaction or occurrence as the claim that it's responding to, which is the events of December 3rd, 2012. And it's a claim for equitable recoupment because it's seeking to offset Mr. Davis's liability on the Transit Authority's contribution and indemnification claim. So even if the statute of limitations argument can go forward, even if their A5 statute of limitations argument is valid and you're looking at the merits, we certainly don't think it's a winner. We think this is a case of equitable recoupment, among other things.
Okay, thank you. You could go on to the causation argument, please.
So, Your Honor, we have two relatively straightforward arguments on causation. Maybe you can even look at them as three. The first of which is that a reasonable fact finder could determine that Mr. Davis's use of physical force in self-defense was a normal and foreseeable consequence of the situation created by the transit authority's negligence. The transit authority failed to take action against a highly intoxicated, aggressive man who then followed Mr. Davis, laid his hands on Mr. Davis, and threatened to kill Mr. Davis. So we think in this situation, it was normal and foreseeable that Mr. Davis would reasonably fear for his life and use physical force in self-defense. So this clearly isn't, as a matter of law, an independent intervening act. But second of all, Your Honor, as far as the injuries that Mr. Davis alleges, we think that these are also reasonably foreseeable, or that a reasonable fact finder could infer that they're reasonably foreseeable. Because where an individual uses physical force in self-defense, even justified self-defense, as it was here in the case of Mr. Davis, those type of activities might lead to arrest or incarceration. So we think that chain of causation here is very straightforward, especially at the pleading stage, where all Mr. Davis needs to plead under Deridarian is that the transit authority's negligence was a substantial cause of the events that led to his injuries. We think that we more than satisfy that standard for purposes of pleading. Finally, as Your Honor pointed out, we do allege certain, let's call them pre-push injuries, which are the emotional distress and mental anguish that Mr. Davis suffered contemporaneously with the assault and battery. Those injuries would survive even if this court adopted the exact same analysis as the trial court and found that Mr. Davis's push was an independent intervening act that severed the causal nexus. So those are our arguments about proximate cause, Your Honor.
Okay, thank you. All right, let's hear from the transit authority.
Yes, this is Tim O'Shaughnessy from the Transit Authority. Can you see me?
You're a little hazy, but we can see you. You're
All right.
You're blurred, as they say. You have a
I
blurred
hope
map.
my speaking will not be blurred. In his reply brief, Mr. Davis claimed that we did not raise below the argument that there was no negligence because there was no breach of duty to Mr. Davis. But in fact, that argument was made on page 43 of the record. It was not fleshed out very well, but that allegation does appear there.
Part of the problem in your case, and I'm troubled by it, is the brief that on appeal didn't flesh out a lot of the arguments that might or might not be more successful to you than issues regarding causation.
Your Honor,
the brief on appeal, let me just finish.
Sure.
The brief on appeal appears to be focused on the causation issue only.
Your Honor may be thinking of the statute of limitations argument. I just thought that was too messy. I didn't want to raise it.
And the notice of claim issue, nobody addresses even the merits of the statute of limitations issue, the equitable offset that your adversary just discussed, which they raised. So I don't know how much we can get beyond causation. Can we? Well, you tell me.
Your Honor, I believe that it is absolutely plain that we owed no duty to Mr. Davis. I was saying that as far as the present
issue, though.
I'm sorry?
Can we reach that issue?
Yes, it was raised on page 43 below, and in his reply brief, plaintiff does not even attempt to apothecate a factual showing or legal counterstep that he would have made below had we raised it more clearly. This case is clearly covered by Crossland. Crossland requires that in order for there to be liability, the transit authority employee must see the plaintiff being injured. All that plaintiff has alleged here is that the station agent saw Mr. Hahn screaming and beating on the emergency exit. Plaintiff did not even allege.
Does the argument go beyond what could be decided on a motion to dismiss? Because if your argument goes to whether or not the station agent had notice of what was occurring, and you're relying on affidavits, testimony from employees, then how is that not a factual issue which is inappropriate for a motion to dismiss?
I'm relying on the language of the counterclaim itself, It alleges that the station agent saw Mr. Hahn banging on the emergency exit. It does not allege that he saw anything else. And Crossland requires it, even allegations like saw him jumping the turntable and bumping Mr. Davis are not sufficient under Crossland. It's a subset of the idea that you don't owe a duty to protect person A from person B. You only owe them a duty to protect them from yourself. On proximate cause, all that was alleged was that Mr. Hahn was seen cursing and banging on the emergency exit. So assuming, contrary to Crossland, that we had a duty to do something, it was not a reasonably foreseeable risk that Mr. Hahn then would go on the platform and injure anybody, and in particular, Mr. Davis. So other than that, we'll rest on our brief.
Thank you. Okay, any rebuttal?
Your Honor, we just have 3 brief points in response.
Let me ask you a question, though, what your response is to the Crossland argument. I understand that's not how the court decided it below. The court decided on the proximate causation argument. But what is your response to that?
So the first argument is that we think that this argument's waived. My friend on the other side mentions that the argument was raised below, but if you review the papers, this argument was never raised in the briefing below. It wasn't raised on the motion to dismiss. If you want, I can review all the distinct arguments the Transit Authority made below. None of them are the Crossland argument. Even reaching it on the merits, though, Your Honor, we think we state a bread and butter claim under Crossland. What we're alleging is that Mr. Martinez, the station agent in the token booth, was directly next to the location where Mr. Hahn was yelling and screaming and banging on the station gates. That also happened to be, as per the allegations in the counterclaim, just feet away from where passengers were entering and exiting the station. So Mr. Martinez had notice, actual or constructive, of both Mr. Hahn's behavior as well as the danger that it posed to passengers, but unreasonably failed to take action, for example, by using the emergency phone in his token booth. So that states a claim under Crossland, certainly at the pleading stage. And if we want to move forward with the case, we can, get evidence and we can really figure out what did Mr. Martinez in fact know and was it reasonable for him not to take action. Finally, Your Honor, with respect to the Transit Authority's proximate cause argument, again, this is just the pleading stage. So the standard here is simply, was the Transit Authority's negligence a substantial cause of the events that led to Mr. Davis's injuries? Mr. Davis does not have to show at the pleading stage that every domino is going to fall the exact way that it did to establish a cause of action. So for those reasons, Your Honor, we think we certainly satisfy proximate cause for purposes of prima facie case. And if Your Honors have no further questions, we rest on our papers. Thank you very much.
Right. Any further questions, colleagues? Thank you. Thank you both.
Thank you.
Menkes versus Solomon and Kramer.
Good afternoon, Your Honors. May it please the court. My name is Scott Horn, counsel representing the plaintiff appellant in this matter. It's our contention, Your Honors, that the motion court erred in dismissing the plaintiff's legal malpractice complaint pursuant to 3211A7. Contrary to the motion court's determination, plaintiff has adequately pleaded but-for causation in the form of defendant's failure to pursue and instead stipulate away plaintiff's $600,000 claim for prejudgment interest. Now, this case is unique, Your Honors, because this court has already affirmed the award of prejudgment interest in this very same attorney fee dispute. As such, it may be said that plaintiff's theory of but-for causation has not only been adequately pleaded at this stage, but it's actually been established as a matter of law in light of this court's prior determination. At a bare minimum, Your Honor, for the purposes of this 3211A7 adjudication, it certainly may be a reasonable inference that the defendant's negligence caused plaintiff's $600,000 loss. This is clearly sufficient at this stage to overcome dismissal under 3211A7. Now, when looking at the record, it's apparent that the error here may have simply stemmed from the motion court's misapprehension of plaintiff's theory of malpractice and causation. I point this out in my brief, and if I may very briefly point this out, at page 6 in the record.
Let me ask something, because you're relying on the prior determination in this extensive ongoing litigation to support your client's claim for prejudgment interest. But clearly the circumstances surrounding that award of prejudgment interest are not the same as this. That was expressly based on specific finding having to do with your client's behavior, which caused this litigation to go on further than otherwise would have gone on. And there's no comparable situation in your client's claim. So my question for you is, based on all that, why is this anything other than speculation that your client ever would have been awarded prejudgment interest in this case, as opposed to the other case, which has clearly different circumstances?
Well, Your Honor, I would argue, firstly, that with regard to the prior circumstance and the award of prejudgment interest, this is a 3211A7 adjudication. Much like my colleague in the prior case, we don't need to show that every domino is going to fall in precisely the right way in order to recover. We merely need to show, or allege, I should say, that it's reasonable to infer that a damage or a loss was caused. And in furtherance of that, when we look at the situation in the prior appeal to this court, it was a contract-based claim, and it was an award of prejudgment interest based upon the fact that the attorney, in that instance, my client, had essentially litigated that attorney's right to a certain percentage under the contract. That's exactly what we have in this instance. My client was forced to litigate from the Supreme Court through the First Department all the way up to the Court of Appeals before finally having her right to her percentage that's provided plainly under the terms of the contract vindicated. In fact, no authority less than the Court of Appeals concluded that based upon...
Isn't this case different though? And because it was not, because of the long history, it was not until 2017 in this case that a final determination was actually made that that the amount was entitled to was 12% rather than 40%. And that did not happen. And there was no implication in any of the decisions that it was any actions on his part that was the cause of any delay in obtaining a determination of the percentage owed. Doesn't that distinguish this from the other case where it was specifically found that there should be prejudgment interest based on the actions of your client and her baseless attempts to avoid the clear terms of the agreement?
I would say two things, Your Honor. Number one, when we're referring to the other attorney, we're referring in this instance to Gollum. And Gollum was the attorney who, rather than accede to my client's clear and unmistakable right under the agreement, the Court of Appeals said the plain language of the agreement allowed my client a certain...
So he needs to get to the Court of Appeals to finally win on the argument. Obviously, a lot of courts disagreed about what the language of that agreement was. Your client was ultimately successful, but there was clearly a good faith dispute about whether or not or what amount your client was owed.
And likewise, with regard to the prior award of attorney's fees, there was a good faith dispute that was litigated and ultimately resolved in the Court of Appeals. And as a consequence of that, the award of attorney's fees was not based upon any particular conduct, Your Honor, but it was based upon the fact that it was arising out of a contract. CPLR 5001 speaks in mandatory terms. When the claim arises out of a failure to perform under a contract, prejudgment interest must be awarded. And that was the basis for the award previously, and that would be the basis for the award here. In their respondent's brief, the defendants attempt to transmogrify this controversy from one that's based and rooted in contract into one that's rooted in equity or judiciary law 475. That is just plainly not the case, Your Honor, and it's a mistake to come to that sort of conclusion in this context. These are not disputes between attorneys who came in and took over a case from another attorney. These are contract-based disputes. My client had a contract with Mr. Gollum, just like Mr. Mannheimer had a contract with my client. And it's based upon the plain language of those contractual agreements that ultimately the parties' percentages were determined, in this instance by the New York State Court of Appeals. And when it came time to say Mr. Manheimer's entitled to interest, it wasn't based upon any conduct. It was based upon the fact that the claim arose out of the contractual agreement, the plain language of the contractual agreement. And we respectfully submit, Your Honor, that based upon that reasoning, we have a very clear path to recovering a similar award on right now under a legal malpractice theory as a showing that this was a loss, that the failure to advance this claim and instead stipulate it away was negligent. And by failing to advance the claim, it cost my client potentially $600,000. Now, again, this is 3211A7. So it's not a situation where there's a laying bare of all the proof to try and establish the claim. We've alleged specifically, Your Honor, on numerous occasions in this complaint that there is but-for causation that links the negligent acts of the defendant in failing to advance the claim and instead stipulating it away without my client's knowledge or consent, and a $600,000 claim that could have been recovered had the claim been advanced by the defendants.
All right, thank you. We're going to hear from your adversary now.
Thank you, Your Honors.
You have to unmute yourself.
Good afternoon, Your Honors. Anthony Proscia from Kaufman Dolwich and Volokh LLP on behalf of defendants, respondents. If I could just start off where Justice Kern's questioning was inquiring and addressing the difference between Mr. Manheimer and then subsequently his estate recouping against Ms. Menkes and Ms. Menkes' attempt to recoup against Mr. Gollum are totally separate and distinct. If you look back at Justice Freed's April 2017 order, which is the order that awards prejudgment interest to Manheimer's estate as against Ms. Menkes, there is a delineation as to conduct of improper conduct and improper behavior by Ms. Menkes, which leads to Justice Freed determining that Mr. Manheimer and his estate are entitled to the prejudgment interest. In the section, it says that she engaged in excessive delay, hampered Manheimer's ability, even attempted to not serve him or notify him of the settlement in the get-go of when this all started in 2013. In contrast, Mr. Gollum was holding the money in escrow under a court order, and in addition
by the way,
to that,
let me ask you a question, because the court was directed that Mr. Gollum hold the money, correct?
Yes, Your
Is
Honor.
there anything in that order that said that he had to put it in an interest-bearing account?
I don't believe so, but I don't recall that off the top of my head, Your Honor. What I will note as a fact specific to the escrow agreement, which is raised in the reply papers as to a purported separate breach of contract claim, Ms. Menkes, Mr. Gollum, and Mr. Manheimer in December of 2014 agreed to partial distributions from the escrow so that they could have some money out of the money. Implicit in that is Ms. Menkes agreeing to Mr. Gollum continuing to hold the money while they engage in the appeals. And as Justice Kern noted, this did not get decided at the lower level. Ms. Menkes lost. In front of this court, Ms. Menkes lost. She then went up to the Court of Appeals, and it wasn't until 2017 that Ms. Menkes ultimately won on the determination. Now, counsel has to make this argument because, frankly, if you look back at plaintiff's complaint, who is a lawyer, by the way, with 3 decades of experience, she amended the complaint twice. So we were on the third operative pleading at the time that this motion to dismiss was decided. She was also in possession of our prior motion to dismiss with regard to our first motion, where we specifically said, you failed to plead but for causation on how you would have won and what claim you would have asserted. Instead of addressing that or trying to amplify those pleadings, she just doubled down on conclusory assertions of but-for causation. There are 4 references to but-for causation within the complaint, and just conclusively asserting hey, I would have won if Mr. Solomon didn't screw up my case, without saying what you would have won, on what claim, and for how much. You don't get to just say it. You have to plead it. As this court stated earlier this year in one of my cases in Silverstein versus Pillsdorf, not conclusory assertions regarding but-for causation does not get you across the finish line on a complaint. And again, I'll just note, this wasn't a first complaint, and this isn't a pro se. It's a litigator with 3 decades of experience who practices litigation rights complaints. So with regard to that, that's where I address. Now to the argument with regard to whether this is a contract-based claim.
Right, and I'm going to ask you to be succinct because you've already
Sure.
your time. But
I
certainly Mr.
referenced it as-
Horn more than exceeded his time, so I'll give you a few extra minutes. Go ahead.
I appreciate that. So just to start, Mr. Mannheimer's claim against Ms. Menkes under the Harvard versus LaGrange case, which goes back to the 19th century, there's a finding of an attorney retaining another attorney pursuant to a written agreement results in an equitable lien as against the claim. Therefore, even under the statute, under the case law, Mr. Mannheimer did not assert a contract-based claim that Ms. Menkes can bootstrap to. In addition, under the case law, which was addressed in the Gary E. Rosenberg PC case by the Second Department, it specifically held that an attorney of record's sole lien against the money is the statutory lien under Judiciary Law 475. Now, that's the hypothetical claim that's come up in this case. Under that same Rosenberg decision, the Second Department held that you do not end up in mandatory prejudgment interest under CPLR 5001A. And I might have added one too many zeros, but I apologize. As to the rest of the arguments in our papers, we rest on our brief. Thank you, Your Honor.
Thank you. Mr. Horn, go ahead. You have rebuttal.
Thank you very much, Your Honor. Very briefly, I think this is a really critical point that's come to light here. And if Your Honors will indulge me by looking at this court's prior decision at page 604 and 605 of the record, it's clear when you look at this court's decision that the basis for the award of attorney's fees in the prior case was not predicated upon any concept of equity or improper conduct. And I'd like to read you from this court's decision at page 604 of the record. It says, quote, although Mannheimer was entitled to 20% of net attorney's fees under the plain language of his agreement with Menkes, Menkes resisted his claim and moved to limit him to quantum merit recovery. Under the circumstances, Mannheimer's estate was appropriately awarded prejudgment interest in order to make it whole, citing the Daddario case from the Court of Appeals as well as Samuel v. Druckmann. Now, both of these cases, and in fact, this court's own clear language, involve situations where it's an award of prejudgment interest based upon the agreement and not based upon any equitable concerns. And as far as what my colleague just stated with regard to the nature of Mr. Mannheimer's claim and trying to put it in terms of equity, this court's own language that I just read to you says that it's the exact opposite. My client tried to limit him to equity, tried to limit him to quantum merit, and was unsuccessful in doing it. His claim was rooted in contract. He claimed that he was entitled to the precise percentage that was provided for in the agreement, and good for him, he ultimately won. But my client did the exact same thing. And she made the argument that she was entitled to a percentage. Mr. Gollum, who is clearly, the Court of Appeals said under the plain language, he's only entitled to 12%. He fought all the way to Albany trying to get 40% before losing. And so when you look at this court's own language, Your Honors, it's clear that this was a contract-based recovery, an award of prejudgment interest pursuant to 5001, not any other provision, based upon a failure to perform a contractual obligation. And that's exactly the nature of the claim that my client had against Gollum had she not been negligently foreclosed from advancing that claim by virtue of the defendant's malpractice. If there are no further questions from the panel, I'll be happy to rely on my brief.
Any further questions, colleagues? Thank you. Thank you
Thank you,
both.
Your Honors.
Thank you, Your Honors.
Okay, Winslow?
Yes, Your Honor. Can you hear me?
Yes, we can.
We are here, Your Honor.
Okay, we have 2 respondents, so let's start with, I'm going to start with, just give me 1 minute. Okay,
Sure.
let's start with New York Presbyterian first.
Yes, Your Honor. May it please the court, Gregory Casino for the defendants, respondents, New York Presbyterian Hospital. You gave me 3 minutes. I probably won't even need that. We would just submit that the Supreme Court providently exercised its discretion in granting our motion to compel the pro se plaintiff to provide HIPAA-compliant authorizations since they were relevant to evaluating this case in light of the plaintiff's known medical history and the allegations of in the bill of particulars.
So, and what's left of the case? Is a malpractice claim? Is that all that's left?
Yes, yeah. The plaintiff was involuntarily committed to a psychiatric institution for 9 days based on an alleged he's alleging he was misdiagnosed with mental and physical illnesses when instead he should have been treated for diabetes. He alleges that this admission, involuntary admission and misdiagnosis caused pain and suffering and mental anguish, rendered him unable to work. The foreseeable future will reduce his quality of life, will cause him issues with his diabetes going forward. We would just.
He's saying misdiagnosis. Okay.
Yes.
I don't know. Honestly, we know all those facts and we understand that he's pro se and the pleading is a little prolix, but as I understand it, what's left is a malpractice claim against the hospital, right?
That is correct, Your Honor. Yes.
Okay. All right. Understood. Yeah.
So, and again, we were just seeking, we limited our requests to only going back 5 years prior to the admission at issue. Again, we're not taking the position, we know however Brito is ultimately going to be interpreted, based on this court's, based on Brito, we didn't just say, we're entitled to everything because you alleged, something with your quality of life. And it was narrowly tailored to the allegations in the BP, the damages he was alleging, what showed up in our chart as to the institutions we know he was previously treated at. And if you look at what he submitted in the record, it's what he did submit. He took our authorizations, he wrote all over them, he limited them in ways he should not have limited them. You look at some of the records he did provide. He provided some medical records. We know that there was a prior treatment at NYU approximately a year prior to the treatment in the admission at issue, where there was a similar allegation of a psychiatric admission. He gave us a couple of pages of that. He wrote all over it. This Dr. Hua, who was one of his doctors, he provided a letter from that doctor to say that doctor didn't have anything that was relevant. So it's our contention. This is just a typical medical malpractice case. We're entitled to these types of records. We get them in every single case. This is not some sort of broad-based fishing expedition. And in light of all that, we would just, again, it's limited in time. That we're not seeking that much. And we would just submit that Justice Rackhauer, when she denied his motion to quash our requests and granted our motion to compel, that was a provident exercise of her discretion and should be affirmed.
All right. Thank you.
Thank you.
All right. Let's hear now from Ms. Winslow's attorney.
Thank you, and may it please the court. My name is Michael Leinoff from Lebanon Kaufman, attorneys for the respondent Barbara Winslow. What we have here for our part is a very basic pleading case, Your Honor. Your Honors, the appellant in this case has simply failed to set forth any cognizable cause of action that is not also barred by the statute of limitations. He began by filing a complaint against the hospital and against his mother, Barbara Winslow. Although it was difficult to suss out exactly what cause of action he was asserting against her, I'm very confident at this point that it was defamation and slander as to his mother. The only references to any type of cause of action that I could find in the complaint vis-a-vis his mother were defamation and slander, which he referred to several times, except for in one case where he called them false facts. So there was clearly a defamation case asserted against Barbara Winslow here. We moved to dismiss and asserted that was beyond the statute of limitations. It was more than 1 year since since the incident in question. Thereafter, Mr. Winslow responded to in his opposition to our motion to dismiss and argued that, well, there could very well be other causes of action that he might be asserting against his mother. And the court needs to consider literally any cause of action that he could possibly be conceived of as existing somewhere in his complaint. This obviously is not true, as under 3013, it is the obligation of the plaintiff in a complaint to assert what causes of action are being raised and what the facts are that support those causes of action. In his respondent's brief, he argues, well, this is a case of labels. Labels aren't important. What's important is the facts. To this, we respond, of course, it's an issue. Of course, it's not an issue of labels. We're not talking about labeling things. It's an issue of what cause of action exactly is being asserted. If it's going to be defamation, he can't have it because defamation is time barred. If it's some other cause of action, he can't have it because he didn't assert the facts that would support that cause of action. He also argues that the law would allow redress of a wrong and ignore what he considers to be technicalities in pleadings. To this, we respond, this is false. And in his brief, he cites no authority that would actually support the idea that it's the court's job to pick apart a cause of a complaint and discover some cause of action to assist a plaintiff in finding a cause of action. It is not the court's job. It is the plaintiff's job to establish what exactly it is that he is suing for. You, at no point in your at no point in the proceedings can you simply verbally change the cause of action that you've asserted. If you asserted defamation in your complaint, that's what you're stuck with. If you want to amend that, then you can certainly rely on 3025 either as early enough as of right or by filing a motion. He did neither. He simply tried to argue that his causes of action, that there is some cause of action that you can actually find in there without actually going through the procedure that it would take to change the complaint. He asserted possibly that he may have raised a fraud cause of action. This, of course, is false because a third party can't rely on fraud. Only the party who was allegedly defrauded can bring the cause of action for fraud. He also asserted the possibility that there was a cause of action for emotional distress. Well, that doesn't exist, but there's a cause of action for intentional infliction or negligent infliction of emotional distress. Obviously, intentional infliction is also time barred, so he can't have that one. He can have negligent infliction of emotional distress, except that he didn't plead facts to support it because there was no issue, there was no assertion that he was in the zone of danger, and there was no assertion that there was any family member or close relative who was in any danger that he was forced to observe.
Mr. Lino, I'm just going to gently remind you, you're out of time, so bring this to
I have nothing further. At this point, we rely on our brief.
Listing all the things that he didn't say. All right. That he
That's
didn't.
it.
Okay.
So.
All right. All right. Thank you both. All right.
Thank you very much, Your Honors. Have a good afternoon.
You too. 160 East 84th v. DHCR.
Good afternoon, Your Honors. If it please the court, my name is Richard Walsh from Horing, Willickson, Rosen, de Grugier. I represent the appellant.
Can we stop for 1 minute? First of all, I'm hearing feedback. And I think that we lost Mr. Schneider, who's part of this appeal. No?
I don't think so, but I'll try disconnecting this microphone and see if it makes a difference.
Okay, thank you. That would be helpful. Okay, that seems better. Mr. Schneider, are you there?
Can you hear me?
Now we can.
Okay, I don't see my image on the screen.
No, and I do have to say before we begin this oral argument that we saw your image all afternoon long.
I did too. And then about 20 minutes ago.
Let me finish, because this wasn't a good thing. And you were busy getting up and down and answering phones and you were very busy. If you're going to do stuff while you're waiting to be called, that's fine, but you have to turn off your camera. Okay?
Yes, Your Honor.
All right, we're going to make you tech savvy. That's one of our aims here. All right, and turn off the microphone.
I'm muting now.
Well, okay, fine. Go ahead, Mr. Walsh.
With all due respect, Your Honor, unlike Mr. Chertok, we actually have a change in the law. Regina Metropolitan against DHCR is the change in the law.
Mr. Walsh.
Yes.
Mr. Walsh, this is Justice Shulman.
Yes,
I don't think anyone really disputes that there was a change in the law in Regina. I think, would you agree that one of the critical issues here is the fact that when the DHCR made its final, after going back and forth in May of 2019, Regina, at least at the appellate division level, was in your favor. True?
Not exactly.
Well, I know there was a dissent, but it was a decision that basically you don't believe that the majority decision in Regina at the appellate division level was in your favor?
No, because it left open the possibility that the DHCR could apply the sampling method on remand. So no, that was not necessarily in our favor.
No,
Uh,
I don't.
I'm going to quote from the Court of Appeals.
Said on Regina here.
I'm going to quote.
It wasn't. It did not. It actually, that was what was affirmed by the Court of Appeals. Because I didn't agree with it at that time. I thought, I didn't say sampling method, but I thought the Taylor buildup method was okay, and that was absolutely everything rejected, right?
If I may, Your Honor, footnote 10 from Regina.
I think there's a more fundamental problem here, which is not whether the law changed. And I will give you that it was in flux, and there were reasonable, intelligent minds differing on what to do, but that by the time there was Regina, there was a something you could at least call definitive. You already had a final determination, and you can't revisit something that's final if the law changes after that, or should you be able to?
Well, it's been the law in this state going back to probably the 1900s, where a court has an inherent power to relieve a party from an unjust law or decision based upon the exact phrase would be based upon law. An unjust decision shouldn't be permitted to stand.
Yeah, but finality plays into this too, because otherwise, every time there's a change in the law, then final decisions unravel and we're re-evaluating them. I don't think that's appropriate. I don't think that that's the law either. I mean, that's the countervailing consideration here. Are we going to reopen this after it was final? And what consequence does that have in terms of jurisprudence in a common law jurisdiction?
Well, it will allow this court to correct a mistake that shouldn't have been made in the first instance. DHCR.
But then do we have to open up every DHCR decision that was made pre-Regina, that made a decision based, let's say, on an alternative method of otherwise calculating rent? And we would be going back years.
I don't think that's the issue here, Your Honor, because we made this motion within a reasonable amount of time after Regina. At some point, you would be time barred, but not here.
But not after it was fine. But not until after it was final. You were final.
Well, it was final. That's why we made a motion to renew based upon that fact of Regina. It wasn't a motion to re-argue, and there's no time limit in the statute for making a motion to renew. The legislature, when it amended the CPLR section dealing with renewals and re-arguments, put in a time limitation for re-argument, did not do the same thing for renewal, which means that they had.
Right, but this is a different kind of renewal. This is not, you're not saying, gee, we discovered facts that existed at the time that were heretofore unknown to us. And that kind of renewal, I will allow you, has no time basis. You're saying it's a change in the law, and that, at least by common law, in the other departments, I don't know that we've ever ruled on it, but it's been held that you can't make it once you have a final decision.
Well, I would respectfully disagree, Your Honor, for one reason. It was timely made within a certain period of time, and a change in the law is also a change in facts.
Mr. Walsh, I'm a little confused. If you can clear this up for me. I hope I can. It is my understanding, sir, that when the DHCR issued its final determination in calculating the appropriate rent for this apartment, that you disagree with, and that's fair. In May of 2019, you did not commence an Article 78 proceeding challenging that final administrative PAR decision, correct?
Correct, and there's a good reason for that.
Just humor me, just give me a second. And normally you have 4 months to do that under the CPLR, correct?
Normally you have a certain 4 months.
So what happens is it wasn't until you made your motion to renew in 2020, after the Court of Appeals affirmed the appellate division decision that was issued. I'm sorry if I'm off on the year, 2018, I think. I think that was the year that it issued it. That you then made your motion to renew in some fashion to somehow create an Article 78 proceeding a year later in order for that change of law to be considered, of which was rejected by the lower court. Did I get that process right?
Not exactly.
Okay.
There would have been no right to challenge the original determination by DHCR because it was in accordance with the remand order this court gave. Any Article 78 challenging a decision after remand would have been at best frivolous. We couldn't do that. But the underlying order that sent the court back, that sent sent it back for remand, argument, notice to renew on that one to adjust the underlying legal basis for the remand is of course entirely appropriate.
Okay, let's hear from, do we have any further you have any further questions, Justice Schulman?
No, I'm okay.
Anybody else? Okay, Mr. Schneider.
Thank you, Your Honor. May I begin by apologizing to the court if I had caused any disturbance on the screen earlier. I wasn't aware that my image was being projected in addition to
apology accepted. The irony is we can't see you now.
I'm so sorry.
But we can hear you. Go ahead.
Thank you, Your Honor. I would add to what the court's remarks previously, that appellant's brief does not discuss in any way why this court's previous order denying renewal is not the law of this case, which should be adhered to, and is not res judicata or collateral estoppel as to this appeal. That's completely ignored in both briefs. And also, the courts have established a doctrine with regard to renewal in cases of clarification that imposes a time limit on motions for renewal, and that time limit is sometime before the case is final and beyond being appealed.
This isn't really let me stop you, because this isn't really a clarification. I think what happened is that there was a lot of differing common law about the implications of Roberts, and it really wasn't finally determined until Regina in the Court of Appeals. And in meantime, in all those years, there were lots of adjudications of rent overcharges under the laws as they were evolving in the courts. And the question is, can we revisit that all now, and should we?
I would suggest that you cannot, because in addition to res judicata and collateral estoppel and law of the case, when the appellant failed to appeal DHCR's order that was issued at the direction of this court, it abandoned and waived its claims. And when the 60-day statute of limitations expired, they had no further recourse, and their failure to timely make a motion or to file an Article 78 establishes their latches. And the doctrine of finality prevails in this type of case, and the court should not and really cannot go back and revisit every rent that has been appealed in the past how many years, since even before Roberts and Regina. This court in Nash versus the Port Authority established that a party who allows its appellate rights to lapse forfeits any right to challenge any issue it could have raised.
Counsel, this is Justice Gonzalez. So your adversary says, but this situation is different. The case was remanded, and had I done an Article 78, had I filed an Article 78, it would have been deemed frivolous. So at least under these circumstances, an exception should be made. What do you say?
It cannot have been frivolous because under Article 78, you are permitted to institute an Article 78 proceeding regarding an objection in law. And that is what they had. They had an objection in law as to what the prevailing base date should be and what the base date rent should be. That was the whole purpose of the appeal in Regina Metropolitan, which this same firm was handling at the same time that they failed to bring an Article 78 proceeding on a point of law that they should have and could have preserved for a later appeal, because we knew back in 2018 that when this court issued its decision in Regina Metropolitan, the vote was 3-2, and there was going to be an appeal as of right to the Court of Appeals, and everybody knew that. And I believe that the decision not to appeal, not to bring an Article 78 in this case, they admit in their reply brief that that was purposeful, and they're using the frivolous argument or the futility argument as a cover. They decided as early as 2018 not to go forward with this case anymore, just because of the happenstance that in the Regina Metropolitan decision, this particular case had been referred to. They considered that opened the door to them to take a third bite at the apple, if you will. And I don't believe that third bite or even the second bite is permitted. They really should have kept the legal issue alive by bringing an Article 78 proceeding. And when they failed to do that within 60 days of DHR's order, they forfeited all of their rights with regard to this case. If the court has no further questions, I would also rest on my brief.
Thank you. Mr. Walsh?
Yes, Your Honor. Couple of points. Number one, footnote 10 in the Regina opinion. Likewise, in Regina Metro, the appellate division rejected the reconstruction approach applied by DHCR as violative of the 4-year look-back rule, but indicated in dicta that on remittal, sampling could be within DHCR's discretion. 164 AD 3rd at 428, 84 New York Subs 3rd, 391. As we explained, that suggestion was mistaken. Until footnote 10, the Regina, there would have been no right to challenge the sampling method. That's the change in the law. That is a iconoclastic change in the law. And in the interest of justice, which is the standard I was fumbling for before, this court should not permit the sampling the sampling method that was used by DHCR improperly to stand in this instance.
Sir, excuse me, what is the strongest case law authority that you have that would support allowing us to act in the interest of justice?
I would say it's Ladd versus Stevenson, which goes back to 1889. It's 67 Sickles 325, 112 New York 325, cited at page 4 of the reply brief. Court has the power to set aside a judgment at any time on terms that are just and allow people to come in and defend. And that case is still good law.
Any further questions, colleagues? No. Okay. Thank you. Mr. Schneider, we can see you. Thank you both.
Thank you, Your Honor.
For waiting till the end of the calendar. And at this point, we're going to close this session of the Appellate Division. Have a good night, everyone.